All right, Emily Dixon.
Yes, Judge, we have a motion to modify conditions, if I may, under the court of her community supervision, Judge. She's been on probation for quite some time as of this point. I have those points listed in my motion. She successfully completed DDRF and she's currently receiving mental health services. So she really turned it around, is really doing much better now. Initially, the court wanted, at the time of the plea, no contact with Raylan Snell, who is here, Judge, as well. And Miles as well, the minor child, Judge.
All right, and we can have Raylan Stell come forward. And probation, do you have any objection?
No objection, Judge. The officer sent in a supplementary report asking to amend the conditions. Mr. King, you can come over here. Asking for no harmful or injurious contact with Raylan Stell and Rich Miles. I would like to point out, Judge, Ms. Dixon has been on probation since November 14th, 2023. She is set to expire in November.
All righty. So probation, has she completed everything?
She did the parenting class, and she did the DDRF, and now she's doing outpatient. Community service hours?
Yeah, no.
So those have been completed as well.
CDRA.
Yeah, it looks like she has completed everything. I believe one of the conditions was for her to get her GED, but she says that she starts the GED in the fall.
All right, and so I'm looking at this from the point of she completed DDRL, right?
Yes, sir.
And so based upon that, she probably is not going to be able to complete the GED before her term expires.
That is correct.
All right. So the question from the court is, she's completed everything. Do we want to continue her? I mean, shouldn't she be terminated if she's done everything? I want to discuss termination.
I think that's a good idea, Judge, especially since November is right around the corner. I can speak that about the state.
Well, if it's right on it's just right over 2 months right there. That this whole issue will be resolved.
Well, first and foremost, I think I filed the motion because I know that probation had some wishes from the complaining witness about the change. Just as of now, Judge, and the GED, I know issues there, but I think if she can provide proof that she's in GED services, if that could be allowed as satisfying that condition, because the GED would take her past the point of termination. If they get that in, if we can reconsider the term. Yeah. Yeah. But I think that if the state wants to just keep an eye on her just because of the nature of the offense, I think
we're going to go on the record. Court is calling 2023 CR 8805 State versus Kimberly Dixon. Can I have parties announced for the record?
For the state of Texas.
Renee Munoz on behalf of Ms. Dixon.
All right. And you're Ms. Dixon?
Yes, ma'am.
All right. And so defense, you presented the court with a motion to modify conditions of community supervision to no harmful or injurious contact. And the parties who are subject to the no contact order is Ms. Stell and Miles Rich. Is that correct?
And that's correct, Judge. And Miles Rich is a child under the age of 14, and Ms. Stell currently has power of attorney over him.
All right. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Raylan Stell.
All right, how do you know Miss Dixon?
She's my mother.
All right, any objection to the court? I'm sorry, asking questions?
No objection from the witness.
All right, with regards to this incident that we're here for, I see that she was placed in DDRF, which tells me there may have been some mental health issues. All right, so can you tell the court what assurances you can give me that if the condition were lifted to include no harmful or injurious contact, is the plan for her to live with you or not?
No.
Okay, so she won't be living with you. Are there any plans for her ever to live with you again?
No.
Okay. Now, Miles Rich, how old is he?
He's 7. He just turned 7 on the 12th.
All right. And does he wish to have contact with your mother?
He has autism, so he hasn't verbally said that he wants to see his mom, but I think it benefits him in the long run to know who she is.
All right. And if she has contact with him, how can you assure the court that that will be supervised in some way?
Because he will not leave my sight. He's in my custody and I plan to keep him in my custody.
All right. And with regards to this incident that she's on probation for, how did that come about? Was he not in your sight? Was she babysitting? What happened?
I was living with my now husband and she was doing her own thing and I had stopped visiting for a little bit because I was working almost full time to make do and everything like that. And then I got a call saying that there was a disturbance from the cops to come pick up Miles.
All right. And so how did she come to have Miles in her care though?
That's her son.
Oh.
She's always had him in her custody up until this point.
Ah, so Miles is her
Son.
biological son. Ah, and so now Miles is with you and
Yes.
Miles is your brother.
Yes, my half brother.
Okay. All righty. Thank you so much.
Of course.
Yes. So, and you are Ms. Dixon?
Yes, ma'am.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Kimberly Ann Dixon.
All right, so what's your diagnosis?
It is bipolar type 1.
All right, and are you on any type of medications?
Yes, ma'am.
What medications are you
I
on?
am on Wellbutrin, Seroquel, as well as Propranolol
All right, and how often do you have to take those medications?
every day.
All right, and what's the time schedule for taking those medications?
Morning is the Wellbutrin, that is going to be 400 milligrams. The Petrol as well, 10 milligram. And then at night I have the 200 milligrams of Seroquel as well as the 10 milligrams of the propanol is what it's called, propanol, sorry.
Okay.
Yes.
And I'm sure later court reporter is going to ask you to spell. I can just ask the
Yeah.
questions. I don't have to worry about
Yes,
spelling
ma'am.
it. And do you know your doctor?
Yes.
Who's your doctor?
I can't pronounce her name. She's with the Center for Healthcare on Palo Alto. It's
Oh, you don't need to pronounce it. So how often
Yeah.
do you see her?
I see her last month. I saw her last month. So it's just really depending on, how the month goes. We usually 8 weeks.
All right.
Mhm.
And do you have a case manager?
Yes, her name is Delia. Sorry.
Oh, you don't have to.
Okay.
State name.
Yeah, I'm with the Center for Healthcare on Palo Alto
And how often do you see your case manager?
once a month. And then we do sometimes I guess it's telehealth.
Okay.
So it's usually like once a month, maybe try.
All right. And do you live by yourself or with someone?
I live in a sober living house, Oxford House. I've been there since I got out of DDR.
Oh, and so how long have you been at Oxford House?
Since August 14th
Okay.
of 2024.
Oh. All right.
And she works full-time, Judge.
Oh, you work full time?
Yes, ma'am. I work at Macy's.
Oh,
on
that's
Star Mall.
awesome.
I'm the vendor for Levi's, men's Levi's.
Well, I'm so proud of you.
Yeah.
I'm glad that you've gotten the help that you needed. I know sometimes waiting for DDRF, that's the longest wait in
Yes,
history.
ma'am. It was.
But I'm glad you're doing that. I'm glad you're at a sober living house. The key is you're going to have to stay vigilant and not miss any of your medications. If you feel like there's something off with your medications, just let your case manager know, your doctor know. Just don't stop taking it cold turkey, okay?
Absolutely. Yes, ma'am.
All right. So are there any oral motions?
Along with the motion to modify, Judge, at this time, the defense makes an oral motion to terminate community supervision based upon substantial performance of the conditions of said community supervision.
And when does she expire?
November 13th, Judge.
All right, stating you're opposed to early term. Okay. All right, the court is going to modify conditions of bond to no harm for, to probation, to no harm for injurious contact, and the court is terminating probation. And that will be terminated successfully.
Thank you, Judge.
Thank you, Your Honor.
Congratulations.
So my probation. Oh, thank you, Judge.
You're
Thank you
welcome.
so much.
All
You
right,
have a beautiful day.
you too.
Thank you.
Have a great one.
Thank you.
All right, so it's Bobby, that's who you said?
Yes.
Page 8.
All right, where's she?
She's right here, Your Honor. That's what I'm approaching because
She brought very nice set of shorts. But we have a plea. It's
Let's
just,
do the plea.
all right,
Well, actually. Right?
he's finishing it, but
All right. I don't know why people come to court inappropriately dressed. You know, I saw somebody, they actually stopped them at the security check-in because they're wearing this see-through outfit. That's like, yeah, a body suit that are shorts. I'm like, this is not the gym. Well, I mean, that's not even appropriate for the gym.
in her defense, Your Honor, it looks very nice.
No, there's no defense of that.
I mean,
There are no shorts for court.
She was looking for the fountain.
Yeah, no defenses to that.
So we apologize, Your Honor, but yeah, we have an agreement.
No need for you to apologize. It's not you.
First, I didn't know where she was,
Mhm.
and now she's wearing short shorts, and then I didn't know the rules.
And then she's late for court. I mean, anybody else, any other judge would have taken her to custody for coming late for court, then somebody can bring her dressed appropriately from the jail because she'll be wearing blue or yellow if she's pregnant. All right, Mr. Ovella,
Come on up, sir.
good morning. All right. So counsel, I see, actually, you were recently appointed to all cases.
Yes, ma'am, that's correct.
And there was no objection from you to this attorney being appointed. I think there was an issue with the previous attorney. So I'm gonna set this for a plea deadline date, and final disposition. So on this date, either there's gonna be agreement or either there's gonna be a trial. Norma, if you'll recall this for Thursday of next week?
Correct.
Is it Natalie Mendoza?
You said Al. Is it Natalie or Al?
Who's the defense attorney?
May I approach, Judge?
Yes, what's the name?
Her name is Miss Mendoza, and
Okay, that's not helping me.
okay,
Are they here?
she is here, Judge.
Okay, who's Mendoza? What's your first name? All right, come forward. So what is happening on this case?
Good morning, Your Honor.
Good morning.
Miss Mendoza was accepted into the pretrial diversion, and her case was dismissed, but she was told to be here.
Well, has her case been dismissed?
It has. It has.
To the court, has her case been dismissed?
The
Right,
email
thank you.
was just sent to my lawyer this morning. He's filling in for my lawyer. But I sent him over the screenshot that my lawyer received
Okay,
Yeah.
on the 22nd.
all right, let me look. I think I may see something on this. All right, yes, it's been dismissed.
Can
I
you
know why
take-
you're on the
yeah.
docket. Do you have a copy of the dismissal?
Just the email that was sent to me.
Oh, now I was just wondering if you would like a copy of it.
Oh, do I need one? I mean, I don't need it. I went to the intake on Monday for that, so I'm working on taking that care of. Tuesday.
Okay, sure. All right, then you're excused.
Yeah.
Thank you for dressing appropriately for court.
Thank you.
Do you want to get this missile for my?
May we approach, Your Honor?
Yes,
So this, I believe it's our first setting, Your Honor.
yes, where are we on discovery?
I don't have any.
All right, Dave, who's the prosecutor you conferred with on this?
Brandon.
Brandon?
Oh, yes.
Do you
I'm
know
sorry.
Benitez? Villarreal? Where are we discovery? Is out any medical outstanding? Because I see this as a collision.
Judge, the medical records are in the state's file. I believe they're on discovery. I don't think we've contacted the complaining witness yet. We have a little more time to talk with them and get their thoughts on punishment or restitution, and say we'll be more than happy to look them up.
All right, Norma. Set this for 45 days. There needs to be an offer tendered on that day, and then there, how old are you?
23.
23. And then the next date after that will be a plea deadline date.
Number 8.
All right, we'll be back on September 8th. Once you sign the reset form, you'll be excused. All right, just have a seat. Your attorney will bring it to you.
Thank you, Judge.
You're welcome.
What was that date?
Number 8.
All right, who's here on Devonna Lee Bovee?
That is my client, Your Honor.
All right, See, if your shorts would have been just an inch longer, then it could be like capris. But when they said you were wearing shorts, I thought it was short shorts.
No, they're, I mean, good look. I said they were nice.
But you look fine.
You know what?
Gonna wear pants.
It's hard sometimes to listen to men. Should I say that?
I did.
Objection, Your Honor.
Do they know anything about fashion? I don't know.
Proven fact, not an evidence of speculation. Should I continue?
You know, it's like from the movie The Good, Bad, and the Ugly, where Eli Wallach says, women's fashion, shameless. But your fashion is not shameless. You're fine, okay? When they said shorts, I thought they were talking about short shorts. Those are close to being capris, or as we call them in my day, gauchos or pedal pushers. So you're good. All right, the court is calling 2026 CR 007400, State versus Devonna Lee Bovee. Could I have parties announced?
Dr. Bias on behalf of the defendant, Your Honor.
And are you Mr. Bovee?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
State has complained. We have reviewed, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Bovee, did you review the application for deferred adjudication with your
Yes, I
attorney?
did, Your Honor.
Did you understand it and sign it?
Yes, I did, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading?
Yes, we do, Your Honor.
State, are you proceeding on the motion as presented?
We are, Judge.
Ms. Bovee, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did, Your Honor.
You're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, I did, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, I did, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is, Your Honor.
Ms. Bovee, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, I did, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did, Your Honor.
According to the plea, there's a $1,000 fine to be probated, and the state is recommending deferred. Did you understand that to be your
I
plea?
did, Your Honor.
State defense?
That is the plea, Judge.
That is correct, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did, Your Honor.
Any such motions? Counsel,
No,
any
ma'am.
such motions?
No, ma'am.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be 100 hours community service, restitution, the DOEP course, and regular UAs. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, I did, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, we offer exhibit number 1, including all attachments.
Your Honor, after reviewing the evidence with my client, we have no objections.
State, you may be excused.
Thank you, Judge.
I'm sorry, state, what's her criminal history?
Judge, she has, the only conviction that she has is failure to ID as a fugitive from justice.
All right, thank you. All right. Wait a minute, a fugitive from justice?
Sorry, Judge?
You say a failure to ID, is it from a fugitive, failure to ID fugitive from justice?
Yes. Must be.
What is she a fugitive from justice from, or is that just,
That's not in the TCIC, NCIC. She does have a few other arrests for drug crimes and
Okay.
trespass, but that's her sole conviction.
okay, all right, thank you. All right, Ms. Bovee, did you see the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I did, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I did, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
You know, other than the fact that she was late, she's been a model client for me otherwise, and she apologized for her dressing, but she's grateful for the offer from the state, and she's willing, asking that you accept that, Your Honor, and put it on defer.
All right, if you're drug tested today, what are the results gonna be?
Not good because I fell off the wagon,
All right, so
to be honest.
what did you use?
I used cocaine.
All right, and other than cocaine, have you used any other substances in the past? Well, I mean, but in this case, there's meth. So
Yeah.
have you used meth?
All I can say is it wasn't mine, but I'm guilty of it because it was on my car.
Okay. And so how often in the past have you been using drugs?
A lot.
Okay. So how did you start using drugs?
I got off drugs and then I got COPD and then I got suppressed and then I fell off the ladder. But I was good for a while.
All right, and when did you first start? How old were you?
13. And I'm 56 now. So,
All right, are you employed or retired?
no, I'm permanently disabled.
All right, and what's your disability?
COPD, it's a JPLR.79. That's what they call
All right, and are you receiving Social Security or anything?
it. I'm waiting for it to come through, but
All
I
right,
will get,
so how do you spend your day?
with my grandchildren.
And how old are they?
My grandchild, she's 9.
I'm sorry, what?
She's 9. So,
All right, and does your grandchild live at the home with you?
no, she's
All right. And your husband, has he used?
no, he works for the city. He's never done drugs. He doesn't do drugs. No privilege.
All right, this is what the court will do. There's $1,000 fine to be probated. Regular reporting by Zoom or in person. Regular UAs, proof of employment or SSI within 60 days. No employment as a home health care provider or minors. Field visits 1 time per month for 8 months. TAP evaluation out of custody. Follow TAP recommendations. A referral to felony drug court. You're gonna need to make sure you make all of these appointments, you understand? All right, there's to be 100 hours of community service restitution. I'm gonna order parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be no unsupervised contact with minors. That may change once she presents to the court that she's complete, clean and sober. All right. There is going to be sober support meetings. 1 sober support meeting per week. And the court will sentence you to 3 years deferred adjudication. Probation, is there anything else?
No, Judge.
All right, is there anything else you need from the court to be successful?
Appreciate it.
You're welcome. Did you review the document entitled Trial Court Certification? I'm sorry, and Ms. Abrams, there's going to be no possession of firearms.
Judge.
Did you review the document entitled
Yeah.
Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and
Yes,
sign
I
it?
understood. Sign it.
Because it's plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I understand, Your Honor.
All right, so here's the thing. Drug addiction is very hard. You're gonna have to change people, places, and things, and that's hard to do. But felony drug court is a good program, so if you are accepted into that program, it would probably be for your best, okay? All right, you're welcome. Good luck to you.
Thank you, Your Honor.
You're welcome. Yes,
I'm in a jury trial in Hayes for CPS that day. It's a pretty hard date because we had to get scheduled with the district judge.
I'm sorry. When is your,
September 8th, that week.
when is your trial gonna be concluded?
Well, looks like it's starting that Tuesday.
It's starting on the 8th.
Yes.
Norma, move this to September, is it starting the week of September 8th or is it starting on Tuesday?
Looks like it's Tuesday.
Norma, recall Villarreal for September 2nd. I'm sorry, not the 2nd, September 3rd.
Thank you, Judge.
Welcome. All right. Max Pettis. Can you come down, please? Your attorney's not going to be here today. Have you had any contact with your attorney?
For a couple of months and,
All right, would you like a new attorney appointed?
if,
I mean,
Yeah.
that's up to you.
yeah, that's fine.
All right, no, we can't be wishy-washy. It's either yes or no. If you would like another attorney appointed to you, I'll appoint one to you.
Yeah, that's fine. If I can settle out today.
Okay, just have a seat. We'll get an attorney appointed to you. All right, Diaz? Oh, so what are we doing? Because today is plea deadline day.
Yes, Judge, he's taking a plea. What I've asked the state is to provide me a copy of the plea agreement paperwork because I'm gonna translate it into Spanish. And then we're gonna come back for a plea.
Oh, no, we can do that today.
Well, Judge, I wanted to have it in writing just to make sure because I know with Mr. Diaz, he's an older gentleman and he wants to see it with his children. So he wants to make sure that the paperwork is what I'm saying it is. So I just want to ask the court for maybe even a week and then we can get it done. Not very long, Judge.
All right, Norma? Recall this for Monday, the 27th.
I'm in Pecos that day, but the next day I should be fine, Judge.
All right, Norma, recall it for, hi, if you come forward.
Va a traducir todo en español. Si le doy una respuesta y nomás hace la respuesta en inglés.
All right. Yeah. So your attorney has told me that you've reached an agreement with the state.
Yeah.
All right.
Sí.
Yeah. Okay. So we're gonna come back on Tuesday and state you'll have the paperwork ready before he leaves.
I'm sorry, Judge, I'll make a copy of the paperwork today and they can walk out with this.
All right. So the court is going to take up your plea bargain agreement on July 28th.
Correct.
Correct. All right, thank you. Thank you for rushing over. We were using all of the interpreters for the trial. All right, Reese Hopkins. All right, did the state tender an offer?
They suggested that we apply for PTD, filled out the application, I turned it in. If he's not gonna get approved for that, they said they would follow up with an offer that I think we would be inclined to take, Joe.
All right, so what I'm gonna do is I'm gonna set this for disposition / PTD. So what that means, if he's not accepted in PTD, then we need to take care of it on this specific date.
Sounds good, Judge.
All right, Norm, I need a PTD date. It's PTD / disposition. Yeah. I can do the 24th. August 24th.
Okay.
All right, thank you
Thank you, Judge.
for dressing appropriately for court.
I already got it. Paperwork.
On the case you just appointed me to, Mr. Trevino, we've got something worked out with the state, and it's going to involve taking care of a case that's in a misdemeanor court.
Okay.
Need to get that case filed. It's still in pre-file.
Okay.
So we're going to try and get a rush file on that today,
Okay.
but I'm thinking about resetting that till Monday if that's possible. And that way we can get him back in and get it disposed of.
All right, Mr. Trevino, if you'll come down, please. We're gonna go on the record. Court is calling 2024 CR 6361, State versus Rudy Trevino. And could I have parties announced?
For the state of Texas.
David McLean for the defense.
All right, and you're Mr. Trevino?
Yes, ma'am.
All right, Mr. Trevino, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Louis Trevino.
All right, you were informed by the court that your attorney would not be here today, and you requested that the court appoint you a new attorney. Is that correct?
Yes, Your Honor.
All right, and that new attorney is Attorney David McLean.
Yes, Your Honor.
All right. Do you have any objections with his being appointed?
No, ma'am.
All right, and Mr. McLean, you wanted this recall for what day?
I was gonna try and get a recall for Monday, Your Honor. We've got a case that we need to get filed that is in the misdemeanor court. It is still in a pre-file stage right now.
Mhm.
I spoke to Rick and we're gonna try and get that rush file today. That needs to get taken care of so that we can basically dispose of this MTR and get him. What we're gonna ask is that he be continued.
Okay.
My concern is we do want their, the set is going to be on this. I'm about to. If we rush out, I just don't know how to see if it's a purpose of getting on this. If we can try for Monday, I don't want to make it wrong.
All right, well, let's
Right.
set it for the 27th. We'll hope and pray that everything is moved appropriately.
And what I'll do, Your Honor, just for the record, I'm gonna go contact the misdemeanor court and let them know kind of what our plan is and see if I can coordinate it so it's on the same day.
All right, and then if that involves some sort of plea to the misdemeanor or something with the misdemeanor, Deputy Laura, on Rudy Trevino, he's going to be ordered for the 27th. Defense and state will let you know on Friday whether or not he should be taken to the misdemeanor court before he comes here. Okay?
Good.
All right, thank you.
Thank you very much.
You're welcome.
Thank you, Judge.
You're welcome. All right, then, let's start with Joseph Daniel Dominguez. All right, so, plea deadline day, jury trial, what are we doing?
We need a plea deadline. We got a new plea bargain offer today. I would like one more setting to come back and resolve it.
All right, this is gonna be set for disposition. And
Yes.
This is the final plea deadline day.
Yes, Judge.
What, 2 weeks, 3 weeks?
The longer the better. I'm gone for the next couple of bits, so.
Monday, Tuesday, or Thursday?
Tuesday, August 11.
Norma, is August 11th available? All right. Just have a seat. And once you sign the reset form, you'll be excused.
Yes.
All right, Eddie Dacey is on
On the
Zoom.
Zoom, yes. Find his file.
All right, and states, it's family violence. You have an outstanding case. And then, yes, and so on this one, ballistics was the last time.
We received a test firearms report the day after the last setting, so that's uploaded to Axon and disclosed. And then I did advise Mr. Bunk that regarding the unindicted family violence, they are still pending DNA and GSR, but we can still proceed, I guess, in theory, if we needed to, so.
All right, where is family violence? So what's happening on the family violence case? Because I'm assuming you all want this all.
Yes.
Yes, Your Honor. It's my understanding that we are pending DNA and GSR from the labs.
And when is that going to be ready?
Hopefully soon, Your Honor. I can reach out and try and get a more exact deadline. The labs are.
When we were last set, Judge, I did ask that they.
All right, Mr. Dacey, you need to remove your hat, please. Thank you, Mr. Dacey.
I did ask that they rush filed the DNA and GSR, and they said that they pulled it in their rush batch, so I'll circle back with that.
All right, Norma, recall this in 60 days and state you'll need to be prepared to tender a global offer.
Yes, Judge.
Okay.
All right. Mr. Dacey, we'll have you back by Zoom on September 21st. And you're excused, Mr. Dacey. Your attorney will give you a call. All right, thank you. Rafael Sosa. And Mr. Brock, what is happening with Mr. Sosa? I think the competency evaluation was received.
Yeah, it was, May the 19th, that issue was resolved. That's brought us back to here, our first setting in here. We're still dealing with some discovery.
All
So
right,
I'd like a discovery date if I could.
all right, state, what's the discovery issue?
There, there were some surveillance videos that were taken from homes. And when it transferred over to our old e-discovery system, only the sound came over and not the actual visual. So I have been in contact with the lead detective that submitted the case. Now the issue that we encountered is that it's not transferring over in the new system, but it was an issue with some numbers that needed to be corrected. So those numbers were corrected this morning. So I'm hoping that it will come over overnight, so someone will have access to them.
All right, so what I'm gonna do, you all are gonna have to confer off docket.
Yes, Judge.
I'm gonna set this for discovery and plea deadline date on, Norma, set it for the 21st as well, September 21st.
Got it.
All right, any
See you
questions?
about
sir?
that. Okay. I'll come see you and talk to you. Okay. Thank you.
All right, thank you.
Thank you, Judge.
Wayne Golden.
Okay. Wayne Golden is in custody. We're gonna need a trial setting on that. No, wrong case.
Okay.
No, right case. I need a trial setting on that.
Mr. Golden,
I'll have him, if I could get something on the record with him.
yes.
He's up here.
Do you need it,
No,
outside my
no.
presence? Okay. Mr. Golden, if you'll come down, please.
You can come to your right.
And who is this special crimes or something?
Oh, there.
All right, I'm gonna need you all to confer on a jury trial date before the new year.
We will.
All right, the court is calling 2026 CR 001105 and 2026 CR 001107. State versus Wayne Golden. Can I have parties announced for the record?
Lauren Espinosa for the state.
Charles Buck for Mr. Wayne Golden.
And are you Mr. Golden?
Yeah, no.
All right, so to each parties, the court is going to need an acknowledgement of discovery filed, and I'll sign it today. And today is the final plea deadline date. Off the record, Mr. Buck, you informed the court that y'all are requesting a jury trial?
Yes, and if I may inquire of my client.
Yes. Can you raise your right hand?
Raise your-
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Wayne Golden.
All right, defense, you may proceed.
Thank you. Mr. Golden, you and I have discussed the plea bargain offers that have been tendered by the state, correct?
Yeah,
And I even showed you the parole eligibility chart that I have from the parole department. Is that correct?
yes,
And we've discussed the range of punishment and the enhancement possibilities if we were to go to trial. And is it a yes?
yes, we did.
Okay. And then finally, do you understand that with this particular court, when she sets something for trial, she doesn't allow us to come back later and plead at the last minute. So once we get past today's date, there's no turning back. We're gonna go forth and have a trial. Do you understand that? And knowing all of that and having the discussions we had about their plea bargain offer and parole and your eligibility therefore, is it your desire still to have a trial in the case and not pursue any type of plea today?
I wanna get a plea.
I'm sorry?
I wanna take a plea
You want to take a plea?
at 2.5.
So do you want to go to trial? Or
Principal one.
yes,
All right.
I think we have an issue. I think we can resolve it, Judge.
Okay, thank
Have
you.
a seat. And I'll
Just have a
get back to you.
All right, and then Mr. Bunk, Daniel
yeah.
Agold.
He's on Zoom, I believe.
All right, is he with Carol Elliott? I don't think he is. Carol Elliott is somebody different. Yeah, Agold is not on Zoom, so,
Okay, let me work on that.
and then,
But just so you'll know on A Gold, this is the case that has the original, the case started in 2006.
mhm.
And we were dealing with the prosecutor before Willem, and her name escapes me at the moment. But we're still trying to get the records from 06. So I'll let the state talk about his learnings.
Yes, Your Honor. So we've obtained and provided all of the records from the Department of Protected Family Services that exist to Mr. Buck on this issue. So all that is left is the victim made an outcry at the time that was handled by SAPD, Special Crimes Unit back in 2006. Ms. Jones has been emailing the detective on the new case. To try and get those records. They sent her over to SVU. SVU never got back to her. I'm gonna have my investigator try one more time to go through casual channels to get those records. If that doesn't work, I will be serving them with a subpoena. And then, if they don't respond to that, then we can proceed accordingly.
All right, so this is what I can tell you. This has been going on since February.
Yes, Your Honor, I see that.
And what's gonna end up happening, I am recalling this, and whatever witnesses need to be here, if you don't have that discovery, need to be here. They'll be placed under oath and they'll tell us why we don't have that information or the defense doesn't have that information.
Yes, Your Honor.
And if they don't have that information, file whatever motions and the
Yes.
court will do what the court does.
Yes, Your Honor.
So how much time are you requesting for them to have this? Because it's been since February.
It has been.
If the court be willing to give 30 days.
That's fine.
All right, Norma, I need a reset date. 30 days. And this is a hearing is going to take place if discovery is not tendered. Is that good for you? Counsel?
I'm looking, yes,
All right, we're going to bring it back on August 24th. And counsel, your client can appear by Zoom, but he
Yes.
needs to be on Zoom. All
I'll make sure he is. Thank you.
right, thank you. Then we have David Bevington. And that's a plea.
That's a plea.
All right, Mr. Bevington. All right, and is this an application?
Yes.
All right, probation, this is an application. Court is calling 2026 CR 001877 State versus David Bevington. Can I have parties announced?
Charles Blunt for Mr. David Bevington.
And are you Mr. Bevington? Counsel, you received all discovery. Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Bevington, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading?
I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive count 1 and proceed solely on count 2 of the
Mm.
indictment.
No objections.
Mr. Bevington, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Bevington, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, the state is waiving count 1, proceeding on count 2. They're asking that your punishment be assessed at 2 years in the prison. There's an $800 fine to be probated. The state is recommending community supervision, and there's to be $120 restitution to the Bexar County lab for drug testing. Did you understand that to be your plea?
Yes, sir.
State defense?
Yes, sir.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, regular UAs, and the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations. Then count two, how do you plead? Guilty, not guilty, or no contest?
Yep.
State any evidence?
Yes, Your Honor, CDOC receipts exhibit 1 and all attachments.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain, and we ask you to follow it.
And I read in the stipulations that there is a theft or something that was part of the,
No pending theft, Judge.
all right, thank you. All right, Mr. Bevington, how old are you?
64.
64. All right, if you're drug tested today, what are the results going to be?
I don't know, I'm not sure.
All right, how
Positive.
positive? All right, what have you been using?
Yeah,
Okay, when did you start using? How old were you?
21,
I'm sorry?
21.
All right, so how often are you using?
It's often, I think, I'm weak.
Okay. Do you have any family support?
No, no,
Right. You're homeless? Okay. All right, we're gonna try to get you some help. But here's the thing, you need to make sure you make all of these appointments. Otherwise, the appointments are gonna happen in custody. I don't want to do that. Unless you want me to put you in custody. All right. Because sometimes people are like, yeah, could you put me in custody? Wait,
Maybe doing that. That way when I be good to do it.
I'm sorry,
You
what?
want me to finish the doing, you want me to put in custody. You know what I mean?
Sorry. Could everyone please whisper?
No.
Just-
Okay.
All right, Ms. Abrams, the court is going to sentence him to 2 years in the prison, suspended and probated for 2 years, regular reporting by Zoom or in person. There's to be regular UAs. I want a referral to felony drug court. That's going to be done out of custody. You need to make sure you show up for that appointment, okay? There'll be a TAP evaluation out of custody. Proof of employment or SSI within 45 days. No employment as a home health care provider or with minors. When's the last time you had employment?
About 6 years.
6 years ago?
Well, I'm disabled,
You're disabled? What's your disability?
emphysema and scoliosis.
Okay. All right, just make sure you provide that information to probation, okay? There is going to be 100 hours of community service restitution. I'm going to order sober support meetings 1 time per week. And for every sober support meeting that's completed, an hour of community service restitution will be deemed satisfied. There's $120 restitution to Bexar County Crime Lab for testing. Ms. Abrams, we're not going to be able to do field visits. He's homeless. And can you all help him if he needs a bus pass or something to get to whatever location? They'll help you with a bus pass. Okay, don't sell that bus pass. Okay. Probation, is there anything else?
I'm gonna go take over.
We'll do an $800 fine probated. What that means is you successfully complete everything, you don't have to pay it.
Oh,
The only thing you need to pay is that $120 restitution. Do not do this thing where you say, I can't pay anything, so therefore I'm not going to report. You need to still report.
Right.
Because when there's a motion to revoke or somebody's complaining that you're not doing something, it comes to me and I have to sign off on it, okay? And normally I have a compliance hearing before I sign those, unless, you know, new cases are alleged to have been committed, okay?
okay.
Is there anything else you need for me to be successful?
Thank you.
You're welcome. Probation, anything else? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. All right, I know it's hard out there being homeless, but just make sure you stay in touch with probation, okay? Thank you. Just have a seat, probation. We'll go over conditions.
Good morning, Judge.
Good morning. So let me just tell you what's going on.
Okay.
All right. Crosspoint is going to go visit her because they have to do an evaluation. But here's a problem. She's not taking her medications.
Right. This has been an ongoing problem. She's been on the streets of San Antonio for over 10 years.
So this is what I'm going to do. We're still going to try to work with her. I'm still going to try to get her placement. They're going to go visit her at the jail to evaluate her. I'm having her previous attorney, who's willing to remain on the case. Her previous attorney is going to talk to her at the jail to see if they can talk to her and perhaps get her to take her medications, so that when they come to evaluate her at the beginning of the week, we can say she's taking her medications. Because this placement, they won't accept her if she's not medication compliant. So if we can just get her to take her medication for a couple of days, then we can say she's med compliant. And then they can have their doctors and their therapists talk to her and hopefully get her to stay on her medications. So that's what we're trying to do. And I don't want to do a situation where we put her on the streets, something ends up happening to her or somebody else, because then this case will, she may pick up new charges or something may end up happening to her.
Well, it always does. And that's why we're in this scenario right now. And as you know, it takes the medication to be in a patient's system for up to 90 days.
So if we can just get her to take her medication, they'll probably accept her before the 90 days or the 60 days, but we have to be able to tell them that she is med compliant.
Right.
So her attorney's going to go speak with her and see if we can get her on her meds. And so we can have documentation that she's on her meds, and then we'll go from there.
Okay. And the other option I'd like to have considered is there are shots, clozapine, and things for other drugs that are injectables.
All right. So here's the problem with that, right? And I've done a lot of work. I used to do a lot of work with people who had mental health issues.
Right.
This is the problem with this. When people are at the Bexar County Jail, you can't force them to take their medication. That has to be something that is ordered. So even if I were to say, you know what, let's do the injection, I can't force that on her. There'll have to be an actual hearing. And that takes a while. And I've represented people before where we've had to have hearings to do a forced medication. So doing forced medication is not as easy as people think it is. People think, oh, the judge just says you're doing forced medication. No, you have to have a complete hearing, because if you do forced medication, and I'm not a medical doctor, and something ends up happening, that's on you. Even if something doesn't end up happening, that's still on the judge, and the judge has stepped outside of my authority. So her attorney told me that they're going to go over to the jail, speak to her, and see if we can get her to do her medication. If she decides not to do her medication, they're still going to do the evaluation. And I'll talk to the people who are doing the evaluation. If she doesn't want to take medication, and I'll just beg and plead with them, please accept her and maybe try her at their facility for maybe a month. And if there are some issues, then they can always send her back to me.
All right. The other issue I'd like to discuss with you is guardianship.
All right. So the guardianship thing that's a civil matter. So that's something that the civil courts would have to do. It's not a criminal matter.
Okay, and as you know, I don't have the $3,000 to $5,000 that it's going to take for me to hire an attorney to, get passed through a guardianship.
Well, with regards to the passing through of a guardianship, they do have, like if you call the State Bar of Texas or the San Antonio Bar Association, they will actually have people who do that pro bono. I'm not sorry, who will do that for free.
The state bar, or which one do you recommend that I contact?
Let me give you the number. I'm going to put the number in the chat.
Put the number where?
I'm gonna send you the number in the chat. Just give me a moment.
Okay.
Is Rio Grande Legal Aid also? And somebody else just told me Rio Grande Legal Aid. So I'm gonna put both in the chat for you.
Okay, and is that going to be sent via email or text message or what?
No, it's gonna appear on your screen.
Oh, I need a paper and pencil. Okay.
All right, so I just put one, and let me do the Rio Grande Legal Aid.
Okay, that flashed off. I didn't catch it.
Oh, it's 227-8822.
Okay,
And the area code is 210.
got it.
And then Rio Grande Legal Aid. Uh, 833 329 8752.
Okay.
And also 956 996 8752.
Those are both Rio Grande Legal.
Yes.
Okay.
And McLean, this is your expertise. All right, and so we do have attorney David McLean in here as well. This is his expertise. And are you able to go on Zoom to speak with her a little bit? If possible, or either, do you want me to give her your?
If you would just give her my contact number, ma'am, just so you know, I'm also an associate judge for the mental health courts on the civil side. Okay. So we may be able to get you some resources that way. I know this is a very difficult situation. There's not enough guardians out there. And it's a very, very hard thing to get done. The judge pointing in the right direction on where we're going, what some resources are right now, but we may be able to help you. Let me give you my number. It's 210-736-9966. That's my office. And you can just contact me probably this afternoon. I've got about 3 more courts that I've got to get to. Otherwise, I'd spend some time with you right now. Okay.
All right. Yes.
All right. Please call me this afternoon. What's your name? Just so is it Carol Elliott?
Carol Elliott.
Give me a call this afternoon. I'll be happy to speak with you. Okay.
Thank you so much. I appreciate it.
Yes, ma'am.
All right, thank you. And so we have your information, Miss Elliott, and we're going to reach out to you once the evaluation is completed, and that should be done no later than next week. Okay.
All right, and then so if she takes her medication, she'll be transferred. Do we know where?
We're working on that.
Okay, and then if she doesn't, she's going to remain in custody.
No, if she doesn't take her medication, we're going to have to figure a different route.
Okay.
I will tell you, I want this taken care of no later than the first week in August, but I'm going to try to get it taken care of next week.
All right.
Okay.
Thank you, Judge. I really appreciate it.
All right. You're welcome. We're going to do our best. Okay.
Great. God bless you.
Oh, thank you. God bless you too. Okay.
Thank you. All right.
Bye-bye. Rafael Sanchez. So where are we on this case?
Well, this is his sentencing date.
Anything?
Yes, Judge.
All right. Could I have the file on Rafael Sanchez?
Yes, Judge, and there is an application, probation.
Okay. All right, thank you. just so the record is clear. Just one moment, I'm trying to see what the charge says. All right,
What happened on it was. we had a
three
trial,
counts.
three counts. Jury came back not guilty on two of the counts, on one of the counts, of not guilty, where it was the third count. And then.
Okay,
But they did find him guilty on continued violence.
That's correct. Judge.
and that's count two.
Yes, right. So count one, we were not guilty, count two was good.
All right, and is Judge Her here or not here? I mean, is she in the building or no?
Sorry, Judge?
Judge Her. Because she's the one who did the.
She heard the
jury.
case, yes, Judge.
All right, and just give me 2 minutes. Okay, on the parties who are on, Rafael Sanchez, just give me a moment. Let me see if the judge who heard the jury trial is available. If not, and you all have no objections, I will do sentencing. All right, the court is calling 2025 CR 014986, State versus Tyler Ross Shipman. Can I have parties announced?
Brandon Prater for the state.
Ashley Morgan on behalf of Mr. Shipman.
And are you Mr. Shipman?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Shipman, did you review the application? Is he applying for community supervision
Yes, ma'am.
and not deferred adjudication?
That's
Yes.
that's what I'm aware of, Judge.
All right, because I'm looking at the plea paperwork. Ah, that's correct.
Yes.
All right, thank you. I misread the plea paperwork. All right, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
We are, Judge.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with intoxication assault with a Vehicle-SBI, serious bodily injury, as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand.
All right, court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
All right, so counsels, I'm looking at the plea bargain agreement. And you said y'all are going open on whether or not there's an affirmative finding of deadly weapon?
May I see the? Oh, that is our intention, Judge.
Okay. All right, so your punishment is to be at a cap of 8 years in the prison. There's a $2,000 fine. I'll decide on whether or not there's an affirmative finding of deadly weapon. But, you know, parties can argue. You understand?
Yes, Your Honor.
There is an application for community supervision and the state is silent on your application. There's to be restitution of $120 to DPS, and there's to be restitution payable to the complainant. Did you understand that to be your plea?
Yes, Your Honor.
State defense is at the plea.
That is the plea, Judge.
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Assigning that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Are there any such motions?
No, Judge.
Then to the offense, how do you plead?
Guilty, Your Honor.
State, any evidence?
Judge, office takes in number one, including all attachments.
And no objection, Judge.
All right, and state, have you spoken to the complainant?
I believe we have, Judge. Yes.
And what is the complainant want in this case?
Stand by, Judge. Judge, the pleading witness is seeking.
Okay, because if it wasn't, then we probably wouldn't need the PSI. I could just do things. That's the only reason why I'm asking. But I want to assure you that at sentencing, I'm sure they'll present the information to me that the complainant wants prison time. But I can always keep an open mind, all right?
Yes, Your Honor.
All right, did you review the waiver and stipulation, maybe excuse,
Thank
did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. We'll come back on October 15th. So this will be for a PSI. Ms. Abrams, do a TAP evaluation as well, and a referral to felony drug court. And is there any mental health or anything else?
No, Judge, there's.
All right, we'll see you back on October 15th. At that time, I'll base my decision on your application on any evidence that's presented to me. You need to make sure that you make all of the appointments.
Yes.
So normally what ends up happening, you have an appointment where you go see probation, and then they're gonna send you somewhere else on another day to do your TAP evaluation. So just make sure you meet all of those requirements.
Yes, Your Honor.
And state, if there's any restitution, if y'all be prepared to present that on October 15th.
Yes, sir.
All right, is there anything else you need from the court?
No, Your Honor.
Thank you for addressing appropriately for court.
Thank you.
You're welcome. All right, court is calling 2016 CR 11739, State versus Blake McCloy. Could I have parties announced?
Paul Mendy, State of Texas.
Jay Norton for Mr. McCrory.
And are you Mr. McCloy?
Yes, Your Honor.
Thank you. All right, so we're here on a motion to revoke. The state filed a motion to withdraw. And before the court signs motions to withdraw, the court wants to make sure that the issues and the motion to revoke have been addressed.
Yes, Your Honor. The defense has provided me, in my approach,
Yes.
with proof of the defendant's employment with Pioneer State Bank, as well as proof that he has maintaining residency in Fredericksburg, Texas, where he was ultimately arrested on this warrant that brings us here today. So he is employed, has residency in the state of Texas and Fredericksburg.
That is
We'll give
correct,
that
Your
to Ms. Abrams. So why wasn't he reporting for compliance hearings that the court said? And this whole thing, when y'all were here yesterday about he didn't know he was off of probation, because the last time we were here, probation stated that they did their due diligence to try to get him here for a compliance hearing. And the reason why I have compliance hearings, it's so we don't get to the point of a motion to revoke. So why were you not here for your compliance hearings?
So Judge, it's my understanding he was unaware that it was set in court.
No, he was, because probation has it in their file, and we were here last time. He had a compliance hearing on June 16, 2022. They reached out to him. So this whole thing about he didn't know he was still on probation, I find that suspect.
You know, that was, yes, Your Honor, absolutely.
And then I didn't do anything about his not appearing, and it was recalled for June 23rd. And when those compliance hearings are set, they're set for a reason. So why were you not here?
You know, Judge, again, it's Mr. McCoy's position that he was unaware that he needed to be in court that.
All right, so can Mr. McCoy tell me that? Or does he not want to tell me that? Because a lot of times, this is what attorneys are not aware of. Dismissals, according to the law and the code, the court doesn't have to sign those. Motions to withdraw, according to the code, court doesn't have to sign those. So am I inclined to sign it? Yeah, but I want some truth telling.
I had a prescription deal where there was COVID was happening, and my probation officer reached out to me after, but never told me about a court date or anything. And so I thought it was already done. He told me that I just had some fees I had to pay, and he was like, and I was really confused, but he did not reach out to me via text or phone. And I swear under oath on my children that I never got.
Okay, here's the thing. Please don't ever swear on children.
Okay.
You know, my mom always would say, well, not my mom, my grandmother would always say, you know how sometimes people say, I do this on somebody's grave.
Yes.
My grandmother she was funny.
I swear on my life.
No. You know what my grandmother would always say?
Yes,
don't swear on your children. Don't swear on your life. Swear it on somebody you don't like. Because then if you're not telling the truth,
I can't
then
swear
it's
false.
at least on somebody you don't like, right?
Yes,
So now, was that so hard to tell me that?
no, I appreciate you. Thank you.
There you go. Is there anything else?
No, Your Honor. The report to the court has states that there were new offenses. There are not new offenses in Fredericksburg. We followed up with Gillespie County. The new offenses that appeared were the offenses from this charge that they entered into the database as of.
All right. And Miss Abrams?
Or, that's for the aggravated assault with deadly weapon. The possession of controlled substance with the same benzodiazepines it's been he had trouble with in the year 2000. It's the same, so those will be resolved.
All right. So did I sign this motion to withdraw?
Judge, there's no opposition from probation. He's been expired since 2022.
I will tell you what I found in my time on the plan. Honesty is always the best policy, especially with me. You'll get further with being honest with me than being dishonest, okay?
Yes, ma'am. Sure.
Judge, is this terminated unsat?
Yes.
Okay.
All right, thank you. You're excused. You're welcome. All right, could somebody make an announcement in the hallway for Israel Garza? Court is calling 2026 CR 007872. State versus Israel Garza. Can I have parties announced for the state?
I think Galloway for the state.
All right, this hearing was scheduled at 9 a.m. It is now 11:36 a.m. The defendant has not answered docket. Did someone go out to make the announcement?
I already did, Your Honor. It's negative contact.
All right. State?
Requesting a bond for Your Honor.
All right, that will be granted. The defendant will be remanded without bond. Charlotte Smith.
She's not here, Your Honor.
Morning, Judge.
Morning.
Hi, 2 issues with her. 1, the jail has yet to transport her. And 2, she's still awaiting determination on competency.
All right.
So the evaluation was done. I just have not received a report nor a setting for resolution. And I've already let the state know that.
Let me see. They have her set in magistrate's court for August 27th.
Oh, it'd be great if they sent me the notice.
Yeah. Norma,
Yes, ma'am.
recall this after August 27th.
Yes, ma'am.
They may have been excused.
Yeah, let me just give you the date. And yeah, they say it's set for August 27th.
Okay, cool. Thank you.
All right. We will bring you back on September 3rd.
Thank you.
All right, and the parties on Rafael Sanchez, we can either take you all up at 1:30 because I'll need to read over this because I wasn't the judge who heard the trial, or either we can set it on a different day and see if Judge Hur is available. We don't know when Judge Hur will be available. I'm still trying to get information on that. Okay, all right, thank you. All All right, the court is calling 2025 CR 003-110 State versus Mario Garza. Can I have parties announced?
Megan Galloway for the state.
David McLean for the defense.
And are you Mr. Garza?
Yes, ma'am.
All right, Mr. Garza, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Mario R. Garza.
All right, so Mr. Garza, Attorney McLean was appointed to represent you because you asked that a new attorney be appointed to represent you. Is that correct?
Yes, ma'am.
All right, thank you. Counsel, of course, you have 10 days to prepare. Are you waiving that time?
Yes, Your Honor, I've had an opportunity to confer with my client. We're going to waive our 10 days.
All right. Mr. Garza, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Are you the same Mario Garza who's placed on deferred adjudication in 2025 CR 003-110 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 2 on or about the 10th day of April 2026 in Bear County, Texas. The defendant Mario R. Garza did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
And we leave the ban in our here.
No objection, Judge.
All right, do you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. It is to the United States motion, continue the defendant and alter and amend his conditions for a felony drug court evaluation, holding status in abeyance and ordering the fit force and a no harmful or injurious contact with Andrea Garza.
All right, the no harmful or injurious contact, I don't do that unless the complainant, because is that related to the assault?
It is that case is closed out.
It's been closed, okay.
Been dismissed, Judge, yes.
All right, so you said no harmful or injurious contact with whom?
Andrea Garza.
Is that Andrea EA?
Yes.
Probation?
Yes,
Is-
Judge.
Is this your recommendation as well?
Yes, Judge, the only thing is, that I would say is that if he is not accepted into felony drug court, that SATA not be held with abeyance and that he actually.
All right, this is what the court, are you asking me to follow that agreement?
Yes.
All right. Do you have gang affiliation?
No, ma'am. No, but they got me as confirmed, but I was never.
All right, this is what I'm gonna tell you. Felony drug court may not accept you. So you're probably gonna end up going to SATA.
Okay.
So you can either accept the agreement that y'all have come to, or either if you want, I'll grant the motion, revoke you and sentence you to 3 years in the prison.
Oh, well,
We'll sit back and talk about it a little bit.
no, but I mean, I'll go with the agreement.
You go to the agreement, yeah.
All right, the court will deny the motion, alter and amend conditions to include a referral to felony drug court, the BIPP course, no harmful or injurious contact with Andrea Garza. If not accepted in felony drug court, then SATA, and he's to remain in custody until transfer. Is there anything else you need from the court to be successful? All right, good luck to you.
Thank you, ma'am.
Have a seat, sir. Have a seat.
Thank you, Judge.
You're welcome. Thank you so much.
Hey, Judge, I've got one more, I think, for Mr. Gonzalez.
Angel Gonzalez. Angel Gonzalez.
Come on up.
And is this an MTR as well?
It is, my clients agreed to go to sign up, which was the basis of the MTR. The states agreed to withdraw it, but I wanted to at least get it in front of you so that you do
Yeah, thank
whatever you got.
you. See, you understand.
I understand. Working it a long time.
All right, we're on the record in 2026 CR 003-834 State versus Angel Gonzalez. Can I have parties announced?
Megan Galloway for the state.
David McLean for the defense.
And are you Angel Gonzalez?
Yes, ma'am.
All right, the state is asking to withdraw the motion and to address the issue that's in the motion. What are we doing?
So my understanding that the defendant is now agreeing to go to status, which is the recommendation of probation. So that is the reason that she is.
All right, so here's the thing. You have choices in life, right? Yes, do you understand?
Yes.
All right. How old are you?
40.
All right. So there are always consequences to action. I'm willing to follow the agreement that they come to if this is what you want to do. Otherwise, if you want, I will revoke you and sentence you to 2 years in the prison. Which do you prefer?
I'll do that.
Okay. All right, then the court will sign the motion to withdraw. And he's to remain in custody until transfer to SATA. And I'm going to ask for weekly sober support meetings upon release. Is there anything else you need from the court?
No, ma'am.
All right, good luck to you. Israel Cortez. All right, so we just need to give him a jury trial date, right?
Yes, Judge.
And we were in trial. We just finished a murder. Is everybody ready to go on a murder today? Should I call a jury up? I don't think we're ready.
Judge, we have conferred on the trial date. Court is okay with September 22nd.
All right, September 22nd is when you'll be brought back for jury trial. You need to do the clothing exchange. If there's an issue with his clothing, just let the court know.
Yes, Judge.
All right, do you have any questions?
No, ma'am.
All right, we'll see you back on September 22nd for trial.
Thank you, Judge.
And is that a Monday or Tuesday?
Tuesday.
On this case, do y'all want to do jury selection on Monday or no? No, I mean, what would be easier for you all? Because then if we were to do it on a Monday, then we would start testimony on Tuesday afternoon.
Judge, I'm okay if we can do it on a Monday and start Tuesday.
Okay. State, you think your witnesses will be available on that day?
Yes.
All right, Norma, is this, the 21st is not a holiday, is it?
Not today. No, ma'am.
All right, so we'll bring you over on the 21st dressed for trial and we'll have a jury brought up at that time.
Yes, Your Honor.
Jury selection, Judge, you said?
Jury selection.
Okay, so I should read that.
And so, they'll have him brought up in the afternoon.
For 1:30, Judge?
Yes.
Okay, yes, Your Honor.
All right, thank you.
Thank you, Judge.
Thank you.
Thank you.
We have a bias on page 12, 3 down.
Morning, Your Honor. Early this morning.
Going great.
Good.
Is this a motion to revoke?
It is.
Have you conferred with probation?
I've conferred with the state and,
Did you confer with probation?
well, no, I haven't.
Well, y'all. Ms. Abrams is an integral part of this process. If we don't have somebody here for probation, the entire system breaks down.
So there's a number of new number ones.
Yeah, but
Judge.
Ms. Abrams,
Not afraid.
Ms. Abrams, are they afraid of you? Is that why they won't talk to you?
It's because they're awaiting indictment, Your Honor. So the state's not able to make a recommendation.
I mean, the new number ones are just a failure to identify and fraudulent possession of credit card. Where is George Abaye?
These are-
Come down, please.
Morning.
Good morning. I don't know why they're afraid to talk to Miss Abrams. You know, we're all professionals here. Norma, set this for a contested hearing in 20 days.
August 13th.
All right, August 13th.
Thank you, Your Honor.
That's gonna be your contested hearing.
Thank you.
Thank you. State August 13th, contested hearing on Abaye. Is your client Israel Garza in federal custody?
He is, Judge. He's been in federal.
Garza
custody
Mario.
since he was released on this case.
Okay,
What about Miguel Aguilar?
Yeah.
well, let's do one thing at a time.
Recall that one?
Yes.
Okay.
What is happening with Mr. Israel Garza?
He will be spending a good bit of time in the federal system, Judge.
So, what is who's the attorney on this? The state's attorney?
I don't have an answer to that question.
It's an assault on a peace officer. He's telling me, how much time is your client going to spend in federal custody? How many months?
My guess would be between 8 and 12 years, maybe more.
Okay.
He hasn't played yet, Judge. He's set in September, I believe.
September?
Yes.
Norma, recall Mr. Garza for the end of September, and when we come back at the end of September, you'll need to have some contact with this defense attorney to let us know what the plea agreement is.
I will.
All right.
September 28th.
All right, September 28th.
That's fine.
All right, and who is your other person?
Miguel Aguilera.
He's on page 10 of 5.
Miguel Aguilera. Why is he not here?
I don't have an answer for that, Judge. I spoke to him yesterday. He knows he's supposed to be here. He is in a wheelchair. He's the one whose legs were amputated. And now I understand he's got limited movement in his hands and arms. According to my conversation with him yesterday, I did file a motion to withdraw. He was on my bond when he originally failed to appear, Judge.
All right.
And he's aware of it.
Counsel, do you have any objection to the court recalling this for Monday since he's a double amputee?
I'll be here.
All right, Norma, recall Miguel Aguilera for Monday. If he doesn't show, I'm going to issue a judge's warrant.
He is currently on a PR bond, Judge. The jail wouldn't take him because of his medical condition, so they granted him.
So we'll come back on the 27th.
Judge, you don't by chance have the court's file, do you?
They would have
They
it.
would, okay.
Yeah, if you ask the court, they'll give it to you.
I just couldn't see. What we did today.
All right, Monica, are you ready on Mr. Rivas? All right, the court is calling 2023 CR 4371A, State versus Adis Hernandez Rivas. I have parties announced for the record.
Megan Dalley for the state.
Monica Guerrero for Mr. Hernandez Rivas, Your Honor.
And we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, we're here for sentencing. According to your plea bargaining agreement, you're charged with murder and your plea is punishment at a cap of 35 years in the prison. There's a $2,500 fine, affirmative finding of deadly weapon, no contact with Marco Moreno Vasquez, and of course, there are no applications. Are there any witnesses from either side?
No witnesses from the state, and there's just the evidence.
No witnesses, Your Honor.
All right, then the court will hear arguments. State, you're asking for a cap of 35 years?
Yes, Your Honor, and I'll reserve for rebuttal.
This time, Your Honor, I'm going to be asking that the court impose a sentence of 25 years. My client has been in custody this entire time. He is an immigrant from Honduras and he does have an immigration hold pending. If you look at his PSI, he does not have any prior history. And on the date of this offense, he felt very intimidated by his boss, who was found guilty, I believe, this week and sentenced to 40 years. He expresses to me that he is remorseful and he shouldn't have gone with his boss, but he was scared of him and scared of the consequences that he would receive at the hands of his boss. So for all these reasons, I'm asking for a sentence of 25 under the cap.
And for the record, is there any objection to the PSI or TAP evaluation?
No, Joe, I'm sorry, Your Honor, no.
Oh, no problem. All right, defense. I'm sorry, state.
Judge, we're just asking for the 35 years in prison.
All right, this is what the court is going to do. As previously stated, the court is finding you guilty. The court will sentence you to a $2,500 fine, time and money to run concurrent. There's to be no contact with Marco Moreno Vasquez. There's to be no re-entry into the United States upon serving of your sentence. And the court will sentence you to 30 years in the prison. Did you review the document? I'm sorry, and there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement and you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand?
Yes.
All right. And the court did consider the dynamic of power between you and the co-defendant. All right.
Thank you.
Thank you.
May I be excused?
Yes.
Thank you. I appreciate your accommodation.
Jonathan Alvarado,
Yes, Judge.
are you here standing in for Acevedo on Aaron Trevino?
Yes, Judge.
All right, Aaron Trevino, if you come forward. All right, the court is calling 2024 CR 012859-02 and 2026 CR 002069, State versus Aaron Joseph Mendez Trevino. Can I have parties announced?
And Jonathan Alvarado standing in for Ernest Acevedo for the defense.
And are you Aaron Mendez Trevino?
Yes, ma'am.
Do you have any objection to this attorney standing in?
No, ma'am.
State, any objection to this attorney standing in? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Trevino, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment in each of these cause numbers with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do, Judge.
State, are you proceeding on the indictment as presented and the cause number ending in 6-9? And are you proceeding on the indictment as presented in the cause number 5-9? That's the one with 2 counts. Let me look. Okay, let me see. Yes, you're waiving count 1.
That is correct, Judge. We count 1, proceed on count 2.
Any objection?
No objections.
All right, Mr. Mendez, in each cause number, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in -02, you're charged with theft of property, $30,000 to $150,000. And in cause number ending in 6-9, you're charged with evading arrest, detention with a vehicle. Those are third-degree felonies. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have plea bargain agreements, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Menendez, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to you, your plea punishment is to be assessed at a $2,000 fine probated. The state recommends deferred adjudication. The cause numbers will run concurrently. The state will take in consideration 2026 PF 19119. Did you understand that to be your plea in each cause number?
Yes, ma'am.
State defense.
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years, a TAP evaluation, 200 hours community service restitution, no contact with the following person: the felony anti-theft course 1 and 2, DOEP, and cognitive thinking course. Did you understand those are recommendations from the state? And the court does not have to follow those recommendations.
Yes, ma'am.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, State Officer States Exhibit 1 and all attachments under both causes.
No objections.
All right, and state, have you all spoken with the complainant? All right, thank you. You may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Your Honor, just ask you follow the plea bargain.
How old are you?
I am 19 years old.
All right, would you like to go to the jail today?
No, ma'am.
So why are you doing this? Like, why are you taking vehicles that don't belong to you? Why are you evading the police?
Just heat of the moment. I think I was just a little bit scared.
No. The stealing of the vehicle is not heat of the moment. The stealing of the vehicle is your and whoever you were with going to somewhere, seeing that somebody left their keys in a vehicle and taking what doesn't belong to you. So why are you doing that? Do you want to go to jail?
No.
Then why are you doing this?
Just reckless.
Well, I mean, no, it's not reckless. This is not a reckless taking. This is knowingly, intentionally. So you intended to take somebody's vehicle without permission and you drove it away. So why are you doing this? Do your parents provide you with a place to stay?
Yes, ma'am, they do.
Do they provide you with food and clothes?
Yes, ma'am, they do.
Then why are you doing this?
I don't have obviously there's no reasonable answer for it. It's, regardless, it's just a dumb decision. But over the years, I have reflected on that. I have, I've been to counseling for that. Lots of, family, grown-up adults, they tell me all the time,
But don't commit crimes? I mean, is that something somebody has to tell you?
no, ma'am.
So do you have mental health issues? All right, so then that mental health thing is just something you did that's related to this case for, oh, let me tell the judge I did this so she can go easy on me.
No, I just.
Did you graduate from high school?
Yes, ma'am, I did.
And what are you doing with your life?
So actually just recently I was working at Conduit. It's a call center. I was working there for about 9 months, but it will be 10 months. I just left within the month, like within the last 30 days, I left that job. I did enroll in college, Northwest Vista, so hopefully the next 2.5 years I can get my my cybersecurity diploma.
So are you currently at Northwest Vista? Have y'all started classes?
No, it starts in the fall.
All right, so why are you quitting a job and you don't have another job yet?
Well, that's correct. That's correct. I was trying to find another job before quitting the previous one. I thought I had one lined up because my dad's friend, he owns his own cabinet company. And I thought I had a job lined up there, but they didn't have enough room for me. And then I have been looking at other places.
So why would you quit employment when you don't have another place to work? Because you're dependent on your parents to supply your basic needs. Because otherwise, I don't know anyone, if they were on their own, would say, I mean, unless they just being silly, but I don't know any adult, which you are an adult, that's why you're in adult felony court, who would quit a job and not have another job lined up, except somebody who's dependent on their parents to take care of them. Because legally you're an adult, but technically you're not, because you can't even take care of yourself. You're dependent on your parents for food, shelter, water, clothes, probably to get you here to court. And the other person who was in the vehicle with you when you were driving away, who is that? What's their name?
I'm sorry, could you repeat the question?
What is the name of the other person who was in the vehicle with you when you took the vehicle and when you were speeding? What's their name?
It was one of my old friends on talks.
What is their name?
Devin.
Devin what?
I'm not too sure about.
Yeah, you do know their name.
I promise you.
Oh, no, I promise you, you do know their last name. So what is Devin's name?
I want to say it's Martinez. And I could be a shot in the dark, but I'm pretty sure it's Martinez.
Mhm. I don't think you're hanging around people that you don't know. And probation is going to check into that. And if that is not true, we're going to be back here. So do you want to stick with Devin Martinez is their name?
Yes, ma'am. I'm pretty confident it is Martinez.
And who brought you here today?
My father, but we actually went to go get my grandma. So that's another thing is because I'm not working right now, my grandma does have dementia. So that's another thing I'm doing, taking care of my grandma at home.
No, you're not. The way I say no, you're not, because you're here. You're not taking care of them.
Well, my grandma transitions between my house and my house.
Mm-hmm. And I don't allow people to take care of vulnerable people when they're on probation out of this court. So you won't be doing that. Do you understand?
Yes, ma'am.
All right. 4 years deferred adjudication. There's going to be regular reporting by Zoom or in person, regular UAs, $2,000 fine, probated.
Sorry, Judge, which cause number is this?
Oh, I'm sorry. This is in cause number ending in -02. So 4 years deferred adjudication, regular reporting by Zoom or in person, regular UAs, $2,000 fine, probated. This is run concurrent with 2026 CR 002069 and 2024 CR. I'm sorry, that's the only cause number to be running concurrent with. Take in consideration 2026 PF 19119. There's going to be 200 hours of community service restitution. If you're drug tested today, what are the results going to be? And you're going to get drug tested today.
Yes, ma'am. I believe I will come out positive for marijuana. But that is the only.
Here's the thing, you haven't changed them. Because this incident occurred in 2024, and you knew you had court and you're still smoking.
No, ma'am, I don't smoke regularly, not every day. I know I can tell you that I will come out positive because I do remember I did smoke a few days.
Do you know how often I smoke marijuana?
Probably after Judge.
Yeah, never smoked marijuana in my life. So again, you are somebody who is coming to this court because as a condition of probation, I can send you to the jail. I can send you to the state jail facility, and you decided to come in here probably positive for drugs. That's not a good start. And then you're positive for drugs and supposed to be taking care of your grandmother. No, not happening. Do you understand?
Yes, ma'am.
And you had better change your ways, because if my child were at college, I wouldn't want them around you if you're smoking marijuana because you're a bad influence. So be a good influence. You understand?
Yes, ma'am.
All right. So 200 hours community service restitution. Do the cognitive thinking course. Once that's completed, 50 hours will be deemed satisfied. And I'm going to want the felony anti-theft course. And after that's completed, 50 hours will be deemed satisfied. The remaining community service hours, you need to do those hours.
Yes.
So you have 100 that you need to do. I'm going to want field visits 1 time per month for 6 months. Proof of employment. or full-time enrollment in college. And for the court, full-time enrollment means at least 9 hours.
Okay.
I used to do 16, but people said, hey, we don't do that. So I'm not even going to put just 16. You have to do full enrollment in college within 45 days. There is to be, if there's employment, there's no employment as a home health care provider or with minors. I'm going to want a TAP evaluation. Out of custody, follow recommendations. There to be no contact with the following persons: Daniel C. Beard. And there's to be no possession of firearms. Probation, anything else? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney and that cause number? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Let me explain to you something about life. And people would always say, Stephanie is such an old soul, because I already knew this when I was growing up. I was probably the only child that 11th grade hit. People in my class were like, Stephanie, we're going to be 12th graders. Are you excited? You know, and I told them no. They're like, why not? I said, because we're getting closer to adulting, right? And this is what I know about life. When you're a child and you're living at home with your parents, it's not even hard. My mom only had a few requirements of us. You know what that was? Go to school, come home. That's it. And she would even give us playtime. You know why? Because she said going to school is like work. You've been at school for 8 hours concentrating, and you're not doing anything of that. And at the end of the day, jobs are easy. This job is easy. You know what makes this job hard? People. If you look at any job where people are having a hard day, you know what it is? It's not really about the job. It's about the people you have to put up with. And you ruined that young girl's day because her parents, because she's probably doing great in school, got her a vehicle, and you just decide you're going to come take her keys and go for a joyride, and you could have killed anybody. And then you would have been up in here crying. Do better. Good luck.
Thank you so much, Judge.
You're welcome.
Leaving the first row right here.
Thank you, Judge. You may be excused.
Yes, you may be excused. Please remind the attorney that he didn't sign the certificate for the attorney.
Yes, Judge.
Thank you. Fatima Del Rosario Malara Leonor. I'm so sorry. I know I butchered that. Lindsay, just give me a moment. I'll take you up after I finish with the interpreter.
Yes, ma'am.
Good afternoon, Judge.
Good afternoon. It's like we just saw each other the other day.
Like 5 days in a row.
Yeah. All right. The court is calling 2025 CR 005418-02. Could I have parties announced for the record?
Van Zeven for the state of Texas.
Good afternoon, Judge Alfonso Cabañas for the defendant.
All right. And we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
And are you Miss Leonor?
Yes.
Counsel, all of the documents I'm reviewing with your client, they're in English. Were you able to review those with her in Spanish?
I did, Your Honor.
And do you speak Spanish fluently?
Sí.
Gracias. De nada. Just throwing that out there. All right. Miss Leonor, all of the documents that I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
All right, counsel, have you received all discovery? Did you review it with your client?
I did receive it, Judge, and I did review it with my clients.
Court will find that the state is in compliance with discovery. Ms. Lenore, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. The state will be waiving counts 2 and 3 of the indictment. Additionally, Your Honor, in count 1, there's paragraph A and B. The state will be electing paragraph D. However, we'll be proceeding on the lesser included of paragraph B which is injury to a child caused bodily injury by omission.
All right, so let me make sure I have this correctly. You're waiving counts 2 and 3.
Yes, sir.
Any objection?
No objection to waiving counts 2 and 3, Your Honor.
All right, in counts 1, you're proceeding under paragraph A?
B. Your Honor.
B, okay. And you're waiving paragraph A?
Correct.
And under paragraph B, you're proceeding on the lesser included offense?
Yes, Your Honor. And I'll represent to this court in our preparation of this case. It initially came in as a serious bodily injury. However, in our pre-trials with Dr. Kassoum, who's our expert on child abuse, she gave us the opinion that the injuries suffered by the infant in this case were not life-threatening. The brain bleed was not life-threatening, and therefore she did not, in her expert opinion, believe that it was serious bodily injury.
Okay. All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, the state is proceeding on count 1, paragraph B, the lesser included offense of injury to a child, bodily injury by omission as a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes.
All right, in this case, is there an application?
No, Your Honor.
Okay, because it says on here, the state will make no recommendations.
I was unaware if there was going to be an application or not.
No, there's no application there.
Okay, so any objection to the court just drawing a line through that?
No objection, Your Honor.
Okay. All right, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is.
Miss Lenore, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at a cap of 8 years solid, which means the court can sentence you anywhere from 2 to 8 years. And the state is not going to tell me what they want your sentence to be, just that it's a cap of 8. There's an affirmative finding of family violence. There's to be no contact with the following persons. Affirmative finding of family violence. You're not allowed to own or possess any weapons or ammunition, or to be designated as primary custodial parent.
Yes.
Did you understand that to be the entirety of your agreement?
Yes.
State defense? Is that the agreement?
That is the agreement.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense and the lesser included offense and count 1, paragraph B, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. The first piece of evidence, there are 3. The first is the stipulations that the court has in front of it, State's Exhibit 1. The state also would offer State's Exhibit 2. These are medical seal, Your Honor.
Okay.
No, Judge, states 1 or states 2 under seal, Your Honor.
Finally, Your Honor, State's Exhibit 3. Provided by this defendant to law enforcement. It has been translated by a certified translator, provided to the defense in the timely manner.
And no, Judge, it states 3.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, if you understand, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments and also states exhibits 2 and 3, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you all proceeding with sentencing, or do you want to set it for a PSI? Or if you want to set it for a PSI, how much time will we need, Ms. Abrams? 6 to 8 weeks, or if y'all want to come back in 2 or 3 weeks and y'all bring whatever witnesses you would like to bring.
No, the state has only the 2 exhibits that have been provided, so the court has sufficient time to review those. That the state would have no objection.
I'm a fast reader. I've read them. So if you want to come back at a different date, counsel?
Sure, that's fine, Judge.
Do you want the full 6 to 8 weeks or a full PSI, or?
No, Judge, I think 2 to 3 weeks will be.
All right, so 2 to 3 weeks?
Yes, Your Honor.
What's best for you? And Yaya? Yes, sir. If you make sure that these 2 are under seal. Yes. And that states exhibits 2 and 3. Okay.
Judge, 2 to 3 weeks will take us into the week of August 3rd, correct?
Yes.
I can do any of the days on August 3rd through the 7th.
All right, Ms. Ferguson, August 3rd through the 7th. All right, August 3rd?
Yes, Your Honor.
All right, we'll come back on August 3rd, and at that time, the court will make its decision. All right, thank you.
Okay, thank you,
Thank
Judge.
you. Do you need me to sign anything?
We're good. Thank you, Judge.
All right, thanks. All right, Charles Bonk,
Yes, Judge.
are you all ready on Mr. Golden?
He's there with you, so I hope
Yes.
so.
All right, Mr. Golden. All right, the court is calling 2026 CR 001107, State versus Wayne Golden. Could I have parties announced?
State.
And for the defense?
Charles Bunk for Mr. Golden.
And are you Mr. Golden? Counsel, have you received all discovery, and did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Golden, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
If you move to waive the punishment.
No objection.
Probation, there's no application. Mr. Golden, did you review the court admonishments with your attorney? Did you understand it and cite it in all the appropriate places?
Yes, Your Honor.
You're charged with cruelty to non livestock as a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea with us? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely.
Mr. Golden, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one, waiving the enhancement. Punishment is to be assessed at 3 years in the prison, and there are no applications. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State officer.
No objections.
Did you review the waiver? State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
I believe he's worthy of the plea bargain. I ask you to follow it.
All right, the court is going to sentence you to 3 years in prison, give you credit for any time served. There's to be no ownership or possession of any livestock or non-livestock.
Yes, ma'am.
There's to be no contact with minors. There's to be no contact with anyone over the age of 60. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And counsel, I did sign the dismissal and
Yes, yes, Judge.
2006 CR 001105.
Thank you.
Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you.
Esparza?
Present, Your Honor.
All right.
Coming out.
That's Linda Esparza? Oh, no problem. And probation, there are no applications?
There is, Your Honor.
Oh, there is?
Did-
Oh, why did somebody put NA on this?
Oh, I did those because it was not turned.
All right, just 1 second. Sorry about that. Let me double check.
Your Honor, are they not in there?
I'm looking.
I know I did the waiver. I'm not sure I did the application.
Okay. Well, we'll take care of it.
I apologize.
No problem.
It is a problem because they're recommending it. That scares me.
Yeah, no, let me see something. Yes. Yes, thank you. We're gonna have your client sign it if you don't have any objections.
No, Your Honor, there's an application on two, one ending in 3528 and one ending on 4436.
And so we'll have her sign it. And then I'm gonna need you to come to court at some time when you're back in court and sign the part for you as well. Oh, no, you won't need to sign it. I'm sorry. So Ms., those are applications for probation. That's just letting the court know that you want probation. Okay, you're welcome.
I'll fill up the case information.
And Lauren.
I'll just add in your name and the case, I'm gonna tell them.
So probation, there are applications. And I'm sorry, I have one more. All right, the court is calling 2026 CR 003528 and 2026 CR 004436. State versus Linda Ann Esparza. Can I have parties announced? And for the defense?
Eric DeWalt, and I represent Mr. Esparza. I believe there's one more case, 2025 CC. Oh, no, there's a JSET case in there, but that's a county court case.
Yes. And are the applications for deferred adjudication, counsel, or no?
Straight probation, Your Honor.
All right. Counsel, have you received all the discovery in each of these cause numbers and reviewed them with your client?
I have, Your Honor, evidenced by my signature on the forms.
Right. And each cause number, the court will find that the state is in compliance with discovery. Mrs. Esparza, in each case, did you sign the application for community supervision? And in each case, did you review the document entitled indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictments?
I do, Your Honor.
State, and cause number ending in 28, are you proceeding on the indictment as presented?
No, we're proceeding on count 1, paragraph 2, waiving paragraph 1.
No objections.
And in the cause number ending in 36, are you proceeding on the indictment as presented?
Proceeding on count 1, waiving count 2.
No objections.
All right. And each of those cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right. And cause number 2H, you're charged with burglary of a habitation. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in the prison and up to $10,000 fine. And cause number ending in 36. Y'all said you're proceeding on count 1?
Yes.
Okay. You're charged with theft of property, $2,500 to $30,000 as a state jail felony. I'm sorry. They're going on authorized use, right? Because you said there's count 1 and there's count 2. And I think on that one, you're proceeding on, let me see. That's the one where you're proceeding on count 1?
Yes, sir.
Okay. So under that cause number, according to the indictment, count 1 is theft of property, $2,500 to $30,000. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, I don't have to follow your plea. If I don't and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Mrs. Esparza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering into either of these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it? All right. In each of the cause numbers, the state is recommending community supervision. These cases are to run concurrently, and they're also to run concurrently with 2025 CC 016789 and and the state will take in consideration 2026 CR 003579 and 2026 CR 003578. And in the cause number ending in 28, they're asking that your punishment be assessed at 5 years in the prison and $1,000 fine. And in the cause number ending in 36, they're asking that your punishment be assessed at 2 years in the state jail facility. Did you understand that to be your pleas? Defense and state, is that the plea?
Your Honor, are there 3 cases taken into consideration?
No, I only have,
I guess I forgot to put one on, but you've given us.
yes, I've given the dismissals on 3, and I'm just reading what's in the paperwork though.
Okay, one was probably dismissed outright, but it's 7-6, 7-8, and 7-9.
Correct.
In each of the cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions?
No, Your Honor.
Outside the agreement, in the cause number ending in 28, they're asking that your community supervision be for a term of 5 years. In the cause number ending in 36, they're asking that your community supervision be for a term of 4 years. 100 hours community service restitution, the TAP evaluation, felony theft course, regular UAs, DOEP course, cognitive behavior course, and then there's to be no contact with the following. And Sydney, I know you got it right. All right, did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor, state offers states exhibit 1 and all attachments under both causes.
We've had an opportunity to go over that, Your Honor. No objections.
All right, and state, have you spoken with the complainants? All right, thank you. May be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and cite it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, and cause number 2026 CR 003528. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing in that cause number, counsel?
Your Honor, may I ask the court's discretion? I asked to submit a letter to you, and yes, I'm ready to go to sentencing if I can address that letter.
Yes, and I have the letters from Victory Recovery Homes, correct?
Are you aware of that place?
Yes, I am.
I was told you were. Okay, thank you.
Okay. All right, thank you. All right, so in that cause number, as previously stated, the court is going to find you guilty. And I'm so sorry, one thing I'm sure, will they pick her up?
Are you asking me?
Yes.
I'm not sure, but she still has the county court case that I have to go close that one out. So I've been in contact with Pastor Gregory Sentmore. Are you aware of who that is? He says he
Yes,
knows
and
you.
and usually they will pick them up, but I haven't talked to them in months, and so I don't know if anything's have changed with that, because sometimes funding changes and everything.
Correct. I can check with him and I can let you know Monday morning.
Okay. All right. So in that cause number, the court will sentence you to 5 years in the prison, suspended and probated for 5 years. Probation, she's to remain in custody.
Sorry, which cause number?
Oh, that's okay. It's 2026 CR 003528.
Okay.
All right. She's to remain in custody until transfer to Victory Homes International. And if for some reason they're not going to transport her, just let me know, counsel.
Yes, Your Honor.
And Ms. Abrams, do you have a copy of the letter?
No, Judge.
Could you send that to Ms. Abrams, please? There's a $1,000 fine. That will be probated.
Thank you, Your Honor.
Counsel, has your client ever been diagnosed or this was drug induced?
She has not been diagnosed.
Have you ever had any type of mental health diagnosis?
No.
All right. Have you ever been prescribed any type of medications?
No.
Do you have any family here?
Yes.
Okay, who's your support system?
My mom and my son.
Okay,
They're both in the courtroom, Your Honor.
all right, thank you. Where's the mom in the mom? Has she, oh, mom, if you would come forward briefly.
Over here, you're back against the counter.
Ah. Hello. Hi, I'm gonna order her to go to the Victory Homes International, but I wanna make sure that's the appropriate placement.
I agree with that too.
Okay. Has she ever had any mental health issues before?
Yes.
Okay,
It's always too many.
all right.
She was denied.
Has she ever been diagnosed with anything?
Well, no, she never did get diagnosed, but me as a parent could see it.
All right, so what we're gonna do is, counsel, and I hope you have no objections that I'm not taking her under oath.
No, I'm fine, Your Honor.
Okay. We're gonna have her transferred to Victory Homes. And we'll do, Ms. Abrams, can we do a referral to Center for Healthcare Services? And we'll do a referral for Center for Healthcare Services, and they'll let us know if there are some issues. And if they are, we'll take care of it and address it. Okay? All right, thank you so much.
Thank you, Your Honor.
Thank you. Oh, God bless you too. So we'll do a referral to Center for Healthcare Services. This is to run concurrent with 2025 CC 016789 and 2026 CR 00436. And taking consideration 2026 CR 003579 and 2026 CR 003578. And was there another taken into consideration, counsel?
Your Honor, I believe the 2026 CR 003576 was just dismissed outright. I think you have 3 dismissals there.
Okay, and I have signed all the dismissals.
Okay.
There's to be regular reporting by Zoom or in person. Regular UAs. We'll do a TAP evaluation out of custody. And we can do a referral to felony drug court. Because if there's a mental health issue, they can do dual diagnosis with her as well. And what I can tell you, if you're accepted in a felony drug court, they'll let you stay at the Victory House International because they worked with them before, okay? And there's to be 100 hours of community service restitution. Ms. Abrams, if she completes the cognitive behavior course, then the community service hours will be deemed satisfied. I don't know if this is cognitive or if it's drug induced or mental health. There's to be no contact with the previous persons mentioned. And there is to be proof of employment within 45 days of release, no employment as a home health care provider or with minors, and no unsupervised contact with minors. Probation, is there anything else? Yes. Field visits 1 time per month for 6 months. Anything else, probation? Is there anything else you need from the court?
No.
And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, next we're going to proceed in 2026 CR 00436.
4436.
Okay. Thank you, counsel. And that cause number, the court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 4 years. You to remain in custody until transferred to Victory Homes International. There's $1,000 fine probated. This will run concurrent with 2026 CR 003528 and 2025 CC 016789. Taking consideration 2026 CR 003576. Regular reporting by Zoom or in person, TAP evaluation out of custody, referral to felony drug court, 100 hours community service restitution, 100 hours will be deducted upon completion of the cognitive and behavioral course. There is to be no unsupervised contact with minors, field visits, 1 time per month for 6 months, proof of employment within 45 days of release, no employment as a home health care provider or with minors. And there's to be no contact with the previous persons mentioned. All right, in that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Make sure you stay in contact with probation. If there are any issues, let them know about it. And well, just be honest, okay, with any evaluations that are done, because our goal here, and my goal is to get you the help that you need, okay? All right, good luck to you.
Your Honor, if I may, can I ask the state to write a note to County Court 15 about the last case number, just what their intentions were?
I already did.
She said she already had.
I heard that.
All righty.
Have a seat, ma'am.
Your Honor, thank you very much. May I be excused?
Yes, you may be excused. Yes.
Where do they go?
They'll pick her up from the Bexar County Jail. No. It's going to be in the directive from the court. That's who she's to be released to. If for some reason their funding has changed and they don't pick them up, her attorney will let me know. We'll make arrangements.
If her mother wants to call me, tell her to feel free.
Oh, and her attorney said, just call them. All right, you're welcome.
Thank you, Your Honor.
You're welcome. Okay, thank you. All right, the court is calling 2026 CR 007429 State versus Jonathan Alcacer. Can I have the parties announced?
Fernando Cortez for Vehicle-SBI.
And are you Mr. Alcacer?
Yeah.
All right, we're using an interpreter. Could you raise your right hand? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record. All right, counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
I do, Your Honor.
And were you able to explain all these documents to your client in Spanish?
I was, Your Honor.
Mr. Alcacer, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yeah.
You're gonna have to speak up.
Yes.
All right, counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Alcacer, did you review the true bill of indictment with your attorney? Did you understand it?
Yeah.
Counsel, do you waive the reading?
I waive the reading, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No, no objection, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, the state is proceeding on the lesser included offense of attempted possession of controlled substance, penalty group 1 to 4 grams as state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Afasar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted. They're asking that your punishment be assessed under 1244 to 136 days in the Bexar County Jail and a $500 fine. Did you understand that to be your plea?
Yes.
Defense and state, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state officer 6, 1 and all.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, please.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court will sentence you under 1244 to a $500 fine, time and money to run concurrently, and 136 days in the Bexar County Jail. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes.
Because this plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
Okay, good luck to you and make better choices. You are not allowed to ride a bicycle on the sidewalk. When you're riding your bicycle, you have to know all the hand signals. If you're riding at night, you have to have bicycles that are lit. If there's a sidewalk that's provided, you're not allowed to walk into the street. You understand? All right, good luck to you. Thank you.
Thank you, Your Honor.
You're welcome.
Your Honor, may I be excused?
Yes, thank you so much. All right, are y'all ready on Joe Cantu?
Yes, correct.
All right, and then who does Roger Pettis have, please?
He has Price, James Price is an MTR.
All right, could you bring that up next after this, please? Court is calling 2025 CR 0000107. State versus Joe Louis Cantu Jr. Can I have parties announced?
Corner to the state.
Fernando Cortez for, Mr. Cantu.
And are y'all ready to proceed on the motion?
Yes, sir.
Are you Joe Louis Cantu?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? And did you understand it?
I have.
Are you the same Joe Louis Cantu Jr. who's placed on community supervision and this cause number for the offense of arson with intent to damage a habitation or place of worship on February 25th, 2025 for a term of for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1 on or about the 26th day of April 2026 in Bexar County, Texas. The defendant, Joe Luis Cantu Jr., committed the offense of resist arrest or transportation in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 2 on or about the 13th day of April 2026 in Bexar County, Texas. The defendant, Joe Luis Cantu Jr., did then and there fail to submit to drug testing as directed by the court officer, supervision officer in violation of condition number 2.
How do you plead to that?
I took my drug test, finished out of my drug tests.
So here's the thing. Either it's true or it's not true. If it's not true, then it's not true. So are you saying it's true or not true?
From my recognition, I took all my drug tests, from my understanding, not even miss any or anything that's in it.
Okay.
Well, I don't understand what I'm being completely charged with either.
Oh, so you're on probation
Yes.
for arson.
Yes, ma'am.
And probation has filed a motion to revoke. And it's this document here.
Yes, ma'am.
So probation is a contract with the court. You're given probation, and in exchange for that, you say you'll do certain things. So one of the things you're not allowed to do is pick up new charges. So what you've pled true is committing the offense of a resisting arrest or search or transportation. So they're saying that you did that. And now they're saying that you didn't submit to drug testing. So they have two things. And they have, in this motion, they're saying that you didn't submit on January 21st, 2026, March 27th, March 31st, April 8th, April 13th, April 24th. Those are the days that are in this motion where they're saying that you didn't submit. And then they have a 14F, and they're saying that you didn't provide any documentations that you signed up for the anger management class. Now, when they have these allegations in the motion, sometimes they won't go on every allegation, even though they think you've committed everything, because they're not supposed to put anything in this motion that they don't believe that you committed, all right? So they may not go on all of this. They're just going to go on some of it. So do you understand?
Yes, ma'am.
All right, so you've pled true to number 1, and
At the end of my probation, right before I was arrested, I had missed the drug test. I'm gonna be completely honest with you.
so she's read
That's
a
one.
failure to miss.
Yes.
I mean, I'm sorry, a failure to test.
Yes, ma'am.
So is that true or not true?
That's true.
Okay.
State will waive the remaining.
So they're not going to go on any of the other allegations. So the allegations that they're waiving, that means they can't bring these specifics allegations up for these specific dates. You understand?
Yes, ma'am.
So we're done with those. We're just going on 1 and 2. Now, you've pled true to violations of 1 and 2.
Okay.
Now, do you want to continue pleading to that? Because whether you've made an agreement with the state or not, I don't have to follow that because it's a contract with the court.
Yes, ma'am.
So what I can tell you is the most I can sentence you to is 8 years in the prison. You understand?
Yes, ma'am.
All right. So knowing that, do you still want to plead true to violations 1 and 2?
Yes, ma'am.
All right. So the court is finding 1 and 2 true. Is there a proposed agreement?
Yes, sir. The proposed agreement is to deny continued probation, but alter and amend for state ISF cognitive followed by ISP for 12 months, and the state will take into consideration clause 2026 CC 007977.
All right. Is that the agreement that
Well-
y'all reached?
Did you say 12 months? Did you say 12 months?
ISP.
For 12 months? Okay, because I asked, and they said it was a 90-day program, and I thought.
No. The ISP is completely from the ISF cognitive. So they're saying they want him to go to IS cognitive. And then when he's out of that, he's going to be in sort of like an intensive supervision.
Okay, yeah,
Okay. So that's what y'all agreed to?
yes.
All right. So what is going on with you? Why are you not reporting? I know there were some mental health issues potentially going on,
I did report, miss.
but why?
I'm sorry.
Why are you not doing what you're supposed to do? Why are you not taking your drug test? Why did you miss that? Why are you picking up new #1 charges? What's going on?
I went to the parade, miss. I just got a new job and I went to the parade to celebrate. When I was walking in the parade, the police walked up on me and they said that, they actually didn't tell me anything. They asked me my name. They didn't read me my rights.
Okay, what is, you say parade or parade?
The parade.
The parade?
Yes, ma'am.
What parade is this?
The nighttime parade. Yes, the Plea-Burglary parade.
Okay.
So I went to the parade. I wasn't drinking or anything like that. And I was walking and SAPD, the bike patrol, just rode up on me and just placed me in handcuffs. Took my wallet, took my cell phone, took my backpack, put everything right there on the sidewalk and arrested me. They said that I refused to search, which I did not. They said that I resisted arrest, which I did not. I let them arrest me and I let them search me. So I'm really in conflict about anything that I'm being charged with. I walk 2.5 miles to report every single time I report. I get off the bus and I go report. When I'm done reporting, I walk another 2.5 miles back to the bus stop. So I was doing my reporting. I did all my classes. I just didn't turn my certificate in at the end. I had one more class missed and I was going to complete my classes. The only thing I wasn't doing was making the payments because I hadn't found a job and it was hard for me to do.
All right, well, I'll tell you, payments is not honestly at the top of my list.
Yes, ma'am. But that's
because I realize that sometimes life is hard financially on people. Payments is at the top of my list when there's restitution owed to somebody.
Yes, ma'am.
And supervisory fees are at the top of my list because that's part of how probation officers are paid. All right. So that's when, but the other payments, nobody knows where they go to. They go to the middle of the universe, never to be seen again. So, probation.
Yes, Judge.
Here's my question. Has he been doing well on probation or not?
Judge did TDRF in November of 2025. He was not making his his appointments with Center for Healthcare Services Business Program and was in danger of being discharged for non-attendance. He did fail to work the anger management class despite the class being free of charge. I don't show that he's completed any of his community service hours. I don't have any information indicating there's been any violations of the no contact order. We have 1 urine test, 2 urine tests. That's it.
I tested, miss. I promise I did. I took every drug test that my probation officer ordered me. The way it sounds, that's not.
Okay, let me explain something to you.
Yes, ma'am.
I've been a defense attorney, and sometimes I would have clients and I would say, look, your trustworthiness with other people, they're like, I know it's 0. I'm like, no, it's less than 0. And I would always tell them, you got to have paperwork to back up on everything. So on the one hand, I'm having you telling me that you only missed one-time testing, and probation has documentation saying you don't test, and it's not just a one-time miss. So this is where we are.
Understand that.
Probation, so do you all want ISF with him?
Summary.
With the ISF miss, when my lawyer explained to me that it was gonna be a 90-day program, not a 12-month program, that's just the
Now, the 12-month program is ISP. That's intensive supervision. It's not a lockdown place.
And which one is the plea bargain?
Now, here's the thing. You can't enter into a plea bargain agreement. These are just recommendations that they're coming to me with.
Yes, ma'am.
So one of the recommendations is they want you to go to ISF. ISF is cognitive to make you start thinking correctly, right? So are you on any type of medication?
I am.
What are you on?
I don't know my medications. I have conditions. I have a condition with my memory. And
I mean, that I know from the past. I'm just trying to see if you med compliant.
my bipolar, my PTSD, and my schizophrenia.
Okay, is ISF even going to accept him?
She would have to go through the medical screening.
I mean, do they normally accept people who are schizophrenic?
Either they got it up for safety.
All right.
Let me double check that.
All right, thank you. Do you have any family support?
I do.
Who would that be?
My mom, my brother, my sisters, my brothers, my nieces and nephews.
Okay.
My BDRF will be out of question this.
Yeah, because this is the problem we're having with you right now is not a DDRF problem.
Yeah, so understand that.
You know, I don't send
I
people.
could understand this if I committed the crime, but I didn't do anything. I was just walking and they just arrested me. So that's why I'm in conflict with it.
All right, so here's the thing. I'm not your attorney. I'm just the judge, just listening to information that people bring me.
Yes, ma'am.
Judge, he can either do safety or he can do DDRF again.
But what's the wait time for DDRF?
A long wait time from what I.
Yeah, it's like 12 months.
Oh, Lord. Oh, my God.
Well, not really 12 months. It's 12 weeks. What is it, 8 to 12 weeks? 15 to 20 weeks.
Like 6 months?
Yeah, but it's not like the Odyssey. You know, you're not going to be on an island with Calypso for
And ISF,
10 years.
ISF is out the question?
Oh, no, we'll send you the ISF cognitive. See how things.
Safety, Judge.
Oh, safety will only accept you. ISF won't accept you. See how we get clarity sometimes?
No.
So safety is a 9-month program.
I did
It's
it.
6 months and then 3 months.
What would you recommend, Judge? Give me honest opinion.
My honest opinion,
Yes, ma'am.
I would recommend having never been here on a motion to revoke. You know, it's like, I always tell people, that's why I always tell people, you're looking at 8 years in prison. So when you ask yourself, I could either go do a drug test or potentially go to prison for 8 years. That's when all these thoughts should have been in, right?
My brother and my mom said.
Yeah.
Yes, ma'am.
So it seems like it's going to be safety.
Is there any DDRF, because I did really well with
The
DDRF.
DDRF, they just told you it's an 8 to 12 week wait.
15.
All right, see, I'm trying to lower it down. It's 15 to 20 weeks.
Is there any way to also, Judge, to maybe consider, obviously, these mental health issues? Is there?
DDRF. We have no other placements.
Yes, ma'am.
So
So I'll be waiting, how many months will I be waiting to wait to go to DDRF?
they tell me it's 15 to 20 weeks.
How many months is that?
Do the math.
15 to 20, that's a long time. Oh, yeah, that's 12.
Oh, they're saying I spent 25 minutes with you, but you know what I say?
Yes, ma'am.
This is your life, right?
Yes, ma'am, it is.
It's like, and sometimes people say, Judge, you spend too much time with people. But what we're doing right now is the most important thing in your world. So this is what I'm going to do. I'm going to deny the motion, taking consideration 2026 CC 0079777. I'm going to alter and amend conditions to include DDRF. And that's to be done in custody. So you'll remain in custody till transfer.
That's fine.
Okay.
Thank you.
All right, you're welcome. And in counsel, if his family wants to come in and if they have another placement for him, I will consider that. We have plenty of time to consider different things because there's a wait time for DDRF, okay?
Thank you, Your Honor.
All right, you're welcome. Good luck to you.
Thank you, sir.
You're welcome. All right, James Price. Mr. Pettis, have you had dinner? Oh, you're on mute, sir.
We are ready.
You. Court is calling 2026 CR 005258. Are you James Michael Price? Okay, you need to speak up so the court reporter can hear.
Yes, ma'am, that's me.
All right, did you review the motion to revoke with your attorney? Did you understand it? Are you the same James Michael Price who was placed on community supervision in this case for the offense of possession of a controlled substance, penalty group 1 to 4 grams? Is that you? All right, state.
Judge, we proceeding on a violation of condition 14A, specifically that on or about the 11th day of June 2026 in Drake County, Texas. The defendant, James Michael Price, failed to follow the recommendations of TAP, violation condition number 14AA.
To that, how do you plead? True or not true?
True.
All right, did you understand by pleading true to violation of 14AA, the court could find it true, grant the motion, sentence you to 3 years in the prison? Knowing that, do you still wish to plead true to 14AA?
Yes.
All right, the court will find 14AA true. Is there proposed agreement?
Judge, after speaking with defense counsel, we negotiated the following agreements on recommendation. The agreement is to revoke the defendant, sentence him to 3 years in the TBC.
All right, is that the agreement, counsel?
It is, Your Honor.
Are you asking me to follow that agreement?
Yes,
Are
Your
you
Honor.
waiving your right to appeal? All right, thank you, State to be excused. Then the court will follow your agreement. Find 14AA true, revoke, sentence you to 2 years in the prison, give you credit for any time served. And the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right. And you're waiving your right to appeal? All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, this is for you, sir. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? The therapeutic community is designed to help you with any mental health issues or drug issues you may have, but I have no jurisdiction to place you in the program. You'll have to request it. It doesn't increase the time that you're in custody. All right, good luck to you, sir. All right, thank you, counselor.
Thank you.
All right, who's here on Efren Lopez? Mr. Sullivan, I'm loving your outfit. I like the suit color.
My wife's dressing me every day a little better.
She's doing great. All right, the court is.
I will say this, Judge, I looked at 3 years left in what I thought how long I was gonna practice law. I'm gonna go back 10 more, so I started dressing.
Okay.
Court. And it was here that it started because every time you have somebody up here, regardless of what they're wearing, you say, and thank you for dressing for court.
Oh, yes, most definitely.
That had an impact on me. Thank you.
Oh, thank you. All right, the court is calling 2024 CR 6133, State versus Efren Lopez. Could I have parties announced?
Yes, Judge, Brian Perry for the state.
Scott Sullivan from Mr. Lopez.
And are you Mr. Lopez? Okay, everybody's whispering. Let me hear the bass in your voice. Speak up so I can hear and the court reporter can hear.
Yeah.
All right, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it? Are you the same Efrain Lopez who was placed on deferred adjudication in this cause number for possession of a controlled substance, penalty group 1 less than 1 gram? Is that you?
Yeah.
All right, state.
Judge Vikky on violation of condition number one, specifically the on or about the 26th day of April 2026 in Gregg County, Texas, the defendant, Ron Lopez, committed the offense of possession of controlled substance PC1, a violation of condition number one.
How do you plead to that? Guilty or, I'm sorry, true or not true? I'm sorry? Okay. Just one moment. All right, can somebody tell me, when I put this in the system in Odyssey, it comes up as Efrain Islas.
Yes, two or three different names.
There's one that says Lopez and one that says Flash.
Isla hyphen Lopez.
All right, it's not in the Odyssey system. I don't know if that needs to be corrected.
Yeah, it says he's still.
No, if you go into Odyssey, it's State of Texas versus Efrain Islas. There's nothing extra.
The MTR on the indicted case?
No, I'm talking about on Odyssey.
Hold on just a second.
On the motion to revoke, it just says Efrain Lopez, but in Odyssey, it says something different. All right, so if y'all put the number in, it says summary, Efrain Islas. Everyone, I'm staying in my lane, but I'm telling y'all that's what it says in there. So if he ends up getting sentenced and it doesn't show it, it's because that's what it's listed as.
He has it
And
as AKA,
it doesn't say AKA in there. So
but it's on the, if you go into the summary page, Judge. Go into the where it says defendant.
demographic.
Yeah, demographic. Yeah, right there on the
Yes,
left-hand side of the bottom.
Yeah, here's the thing. I'm just gonna leave it there, but I'm just letting everybody know. I'm letting you know, sir. Okay. Is there a proposed agreement?
Yes, Judge, the proposed agreement is called the probation recommendation, which is to amend, extend 2 years and amend for SATA followed by aftercare.
All right. And I'm sorry, sir, did you understand by pleading true to number one? I could find it true, grant the motion, find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine? I'm sorry, what?
Yes.
All right. Why are you whispering today?
I'm sorry, my voice too.
Your voice is what?
My throat is too.
Okay.
AC.
So they're saying that they want to extend you and sentence you to SATA
Yes, Judge, with aftercare.
with aftercare. So are you in agreement to that?
Yes, Your
All right, then the court is finding violation of condition number one true. Court will alter and amend conditions to include SATF, so you're to remain in custody until transfer.
Honor. Yes.
I don't know. Does anybody know what the wait time is for SATA?
I was told, I think that probably.
Right now, after you finish the medical clearance, there is no wait.
Ah, there you go. All right, and then there's to be no unsupervised contact with minors. And one sober support meeting per week upon release. Is there anything else you need from the court to be successful?
Oh, yeah.
All right, thank you. Zachary Simmons.
Good.
Good afternoon, how are you doing? Let me give y'all the update.
It's the update, Judge.
All right, so I did receive a letter back. Oh, no. The letter in the form of an email from them saying that they do not have access to that anymore. Now, I did send a follow-up email, and my question was, well, is there any other way that perhaps, it can be discovered? And let me see what they told me. I'm sorry, I'm just looking for their. Thank you, I appreciate it. I tell everybody, everything that's happening in front of me, it's the most important thing in the person's life who's in front of me.
Waiting almost a year for this moment.
Mm-hmm.
Se ve delete email.
All right, state and defense. Y'all wanna come around this way and I'll show you the email that was sent to me. All right, so on Zachary Simmons. Norma, we're gonna set this for a hearing. To give Mr. Cox a chance to see if there's some information out there. So what we'll do is we'll set this in 45 days and state if you can see maybe if there's a way to get the information from the company.
We'll try,
Okay.
try.
All right, thank you.
And I'll get on it.
September 8th.
Thank you.
All right, so we're gonna recall it back on September 8th.
Thank you.
You're welcome. Sorry, it's all purged. I shouldn't say purged. It's gone from the scan system. Hello, Mr. Lopez.
I know.
I'm doing great. How are you doing?
Okay.
All right. So we're here today for discovery. What's happening with that?
I think we're good on that.
Okay.
And we've been trying to reach the complainant. I think we have, and the state has as well, and there hasn't been any recent contact with her. And so that's kind of one of those things that needs to be ironed out.
All right. So has an offer been tendered?
Yes.
Okay.
All right. Do you want to set it for a plea deadline date or jury trial?
Well, Judge, I would say I want it set for a plea deadline, but I also, if we could set it next week, because depending upon what my investigation finds in the next few days, he doesn't have a bond set, and we would like to.
All right, Norma, if you can set this for either Tuesday or Wednesday, I'm sorry, Tuesday or Thursday of next week.
Tuesday's great. Yes.
All right, we'll see you back on the, what is that?
28th.
28th.
Judge, he's on page 8 on the top.
All right, thank you.
All right. Thank you all.
Welcome.
Have a seat, sir.
He's done merit. All right, counsel, what is happening with these cause numbers?
Your Honor, my client got a revised offer today. And the state wasn't going to oppose a very short reset, maybe a week or two at the most, just for us to consider that. And then after that, we got to hit the ground running.
All right. Ms. Ferguson, make this a final plea deadline date, Thursday next week.
Thank you.
Yes, sir.
All right, we're going to bring you back over Thursday. At that time, you need to let me know whether or not you're accepting the agreement. Otherwise, your next setting is going to be a trial setting, okay? All right, thank you.
And that's July 30th.
Yes.
July 30th.
All right, Stephen Worthy.
He's right here.
All right, what is happening with this case, counsel?
We have a plea agreement. I believe it was 3 years deferred adjudication.
All right, probation,
Yes, Judge.
are you ready? This is a plea.
Yes, ma'am.
All right, the court is calling 2026 CR 003174, State versus Stephen Ronald Worthy III. Could I have parties announced?
Megan Gallo for the state.
Leland McCray, have Mr. Worthy, is to my right.
And are you Mr. Worthy?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, and to the best of my knowledge, we have it all.
Court will find the state in compliance with discovery. Mr. Worthy, did you review the application with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, please.
State, are you proceeding on the indictment as presented?
Judge, we're waiting on and proceeding on count 2.
Any objection?
None.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on count 2. Count 2 is possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
very much so.
Mr. Worthy, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. There's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2026 CR 008615. There's $180 restitution to DPS for testing. Did you understand that to be your plea?
Yes, ma'am.
State defense?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
None.
Outside the agreement, the state is recommending their community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, and no contact with Christopher Nieto. Did you understand those were recommendations from the state?
Yes, ma'am.
And the court does not have to follow those recommendations.
Yes, ma'am.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
It offers states one in attachment.
Just really quickly, Judge, did they write, did you write 3? Yeah. Well, no, sure. Sure. You got 5. No, you're right, it's 5. You put 5. This one's 5.
Maybe.
Okay, so you good with 5? Yeah, 5 weeks for the
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulation. Court will accept into evidence states exhibits 1 and attachments and review the same. Oh, and state your excuse. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Just the court accept the plea.
All right. So are you employed? Are you receiving SSI?
At this moment, I have a business called Anything But Mechanics,
Mhm.
but I was trying to get on SSI, but they keep denying my application, so I'm gonna keep trying to do that. But as far as I own a business called Anything But Mechanics, like would be basically anything but mechanics, and it's
I was gonna ask you that. I love that. So you do anything but mechanics.
anything but plumbing to roofing to landscaping to framing to electrics, like electrical work, plumbing, anything.
But
Concrete
mechanics.
slabs, anything but mechanics.
Okay. Why anything but mechanics? Is mechanics, I would think, well, I think they're all hard jobs, but the
I mean,
electrical,
They're really not hard. It's just I'm not a grease monkey,
okay.
and I really don't like to move wrenches. I
Ah.
do it, but I just prefer not to. I'd rather swing a hammer or use a jackhammer or do anything but mechanics. So my friend, he got a little lump of money, and he's like, "Well, what you want to do with it?" I was like, "Well, make me a business called Anything But Mechanics." So
I like that idea. And that's a catchy name. So do you live by yourself? Do you have family support?
I live with my mother,
Mhm.
my sister. Well, we all stay on the same property, but there's like 3 different houses.
All right. So you're gonna have to start making better decisions. How often were you using drugs?
I'm not gonna lie to you, I was using it quite a while, like pretty often.
Okay. Do you have any criminal history?
No, ma'am.
Okay. All right, it's gonna be a $1,500 fine. Referral to felony drug court in custody. They will have that decision made by the beginning of next week. And we'll get the referral in today. TAP evaluation. Follow recommendations. How long does it take to do a TAP in custody?
About a week or two.
All right, so the TAP evaluation will be in custody. However, if you're accepted in felony drug court, their evaluation will be completed before then we won't hold you for the TAP evaluation. Regular reporting by Zoom or in person. Regular UAs, proof of employment or SSI within 60 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. Are there any minors in your household?
Not mine or my mother's, but my sister there is.
All right. Field visits 1 time per month for 3 months. No contact with Christopher Nieto.
That's a mandatory.
Mhm.
That right there has already been done.
All right, 200 hours of community service restitution. And deduct 1 hour for every sober support meeting that is completed. And the court is going to require sober support meetings 1 time per week. Probation, is there anything else?
Is that probated?
Yes, the fine will be probated and then it will be 3 years deferred adjudication. All right, is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. And probation, there also be no possession of firearms. All right, good luck to you.
Thank you.
You're welcome. Okay, and then you have someone else with us, I believe.
George Brown,
Yeah, this is-
page 7.
Yeah, I was gonna ask for a reset to the final plea.
Okay. Have Mr. Brown come up.
Sure.
Hello, Mr. Brown. Okay, Mr. Brown, here's the thing. You gotta make sure you're on time for court, okay? Okay, on this case, have you received all discovery?
To the best of my knowledge, yes.
Okay. All right, this will be the final extension of your plea deadline date. It will not be extended any further. Ms. Ferguson,
Yes, ma'am.
set this in 2 weeks. Is that enough time for you, counsel?
That's fine, yes, thank you.
2 weeks for a plea deadline date?
Yes, ma'am. That'd be August 6th.
Okay, thank you.
All right, thank you. Once you sign the reset form, you're excused. All right, you're set, Canales. Oh, I'm so sorry. Just go ahead and finish that and then,
We have an interpreter.
come on up then. Thank you. And counsel, is there an application in this case?
No, Your Honor.
All right, the court is calling.
Thank you.
Court is calling 2026 CR 007700. We have an interpreter here. Could you raise your right hand? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
And if you'll state your name for the record?
Mariana Rios.
All right, and if parties will announce for the record.
Alfonso Cabañas for the defendant, Your Honor.
And are you Mr. Canales?
Yes.
Counsel, do you speak, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to explain these documents to your client in Spanish?
I did.
Mr. Canales, all of the documents I'm going to review with you are in English. Were those explained to you in Spanish?
Yes.
Counsel, you received all discovery. Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Canales, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State proceeding on the indictment as presented.
Yes, Your Honor. However, as an additional matter, before we do that, the indictment contains 3 typos. The wrong individual was listed as victim, 3 places on the indictment. So in all three places, the state would ask to propose the trial amendment that the name of Jacqueline Guevara be interlineated, replaced with Azarela Ramos Posadas, which is the correct name for the.
Yes.
No objection, Your Honor.
All right, do you understand that's a substantive change to the indictment?
Yes.
All right, and you have a right to have your attorney have 10 days to prepare for trial, and you have a right to force the state to re-indict this case. Do you understand, if they so choose?
Yes, I understand.
All right, knowing that, do you wish to go forward?
Yes.
All right. Mr. Canales, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with assault, family impeding circulation. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison. I'm sorry, 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Are you giving up your rights and entering into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He did, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Canales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
I'm sorry?
Has anyone placed you in fear or coerced you to get you to enter this plea?
No. No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to your plea bargain agreement, there's an affirmative finding of family violence, 3 years in the prison. There's to be no contact with, and there's a $1,500 fine and no applications. Did you understand that to be the plea?
Yes.
Defense and state?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit 1.
No objection to states one, Your Honor.
All right, state you may be excused. Did you speak with the complainant?
Your Honor, we did speak with the complainant. She sent a victim impact statement she would like read on.
All right, thank you. All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just to have the court follow the plea agreement with the state, Your Honor.
All right. The court will sentence you to 3 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's a $1,500 fine, time and money to run concurrently. There's to be no unsupervised contact with minors and no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, I do understand.
If you love somebody, you're not supposed to put your hands on them in anger. Do you understand?
Okay, yes,
Well, I mean, I hope you understand that.
yes.
All right, good luck to you. You want to read victim impact? Hello. All right, let me find you.
Hey, Jake.
Thank you. All right, so what is happening on this case, counsel?
Today's the first setting, Judge, since indictment. My client does apologize for being late. He did not have a ride, but I did stress to him going forward the importance of being here by 9 a.m. docket call to notify the court that he's here so things can run smoothly. I gave him my information, he has mine, so we're on the same page, Judge. I would like to go over the evidence with my clients. The evidence seems whole at this point, and we're going to get some mitigation documentation to the state in terms of some diagnosed mental health issues as well as anger management class, Judge.
All right, Norma, if you'll recall this in 30 days.
May we do August 27th on Thursday, Judge? Fits my schedule a little bit better.
All right, Norma, August 27th. All right, thank you.
Thank you. I'm sorry for them.
No. Now you know, okay?
It won't happen again, Judge.
Okay.